Your permission, Lord.
Other petitioner has challenged the visitation rights order, my lord. The Honorable Court on 7/8 it was directed to registry to post the above matter after the complaint of the respondent, my lord. Akalat has been filed since the matter has not been taken.
Lord, notice was ordered in this matter.
But in this matter, writ petition was already disposed of at your lordship's chamber and he is exercising the overnight. This is regarding his birthday and there was a connected petition. That was not disposed because I think we forgot to mention this. In view of this, 28th is the birthday for the child. It's already there, my lord. It's already granted. But there was a stay operating in another writ petition which could not be disposed of at that time. Yes, there is a stay in this. Because of this, the trial court is saying, I think he will grateful.
Lord, a notice was ordered, Lord, and this matter is directed to be listed on 19th. Since I have not served the copy within that time, it is not listed, Lord. Now I have served a copy and produced the same. Yes, Lord. I have served the copy and Lord filed an acknowledgement. So that it may be taken, Lord. Lord, CPC, Lord, MFA. Please.
In this case, my lord, a fresh matter, my lord. I have filed petition, my lord. Yeah.
Fresh matter, office objections complaint.
Previously, I filed the RPC, my lord. That is
Family
covered.
matter. The family matter, wife is a petitioner. Filed tomorrow. The memo is not yet moved.
My lord, this petition was,
Lord, RPFC case I have filed, that is converted to WP. And now the matter is not listed from last 1 month, my lord. That is the reason I'm knowing, I'm having the urgency.
My ladyship, my ladyship, one matter for 2:30. There is an order. I filed a GNWC petition. The court had granted emergent notice because the husband resides in US. Subsequently thereafter, he moves an application for temporary custody, emergency motion. And now what has happened is it appears that the court has passed an ex parte order, despite the fact I said that I am not subjecting myself to the jurisdiction of the court. The child is an autistic child. The mother and the child are here in India. They are Indian citizens. But the only thing is that the court below, when I moved the court below for advancing the case on 19th, the court below says, no, I have issued emergent notice, I will not advance. There is an urgency in the matter. No, I'm only saying protect me till such time, nothing more. Because an autistic child which is 8 years old, which has got the mind of a 3-year-old child, it cannot be removed. And for some reason, if the order says that send the child. No, no notice, the date of hearing has not been served. I got an order, I sent a reply, it is there. I immediately. No, an order there in the US, it appears on an emergency motion. They send an order. US. The US court passed an order on 12th of September, which was served on me on 13th, saying that serve copies of that particular order, saying that the emergency motion will be taken up. I write a letter to the registry, the deputy clerk of the county court, saying that you have not given me the date. I should be heard physically or I should have the services of an attorney because I'm not subjecting myself to the jurisdiction. The boy is here in India. The boy was also produced before the small child. He's in India. Mother is also in India. Father has moved this emergency motion. That is one aspect of it. No, I will explain. I will also explain what if the matter can be taken up at 2:30, if, no, yes. American court. Yes. Yes. No, there is no order. There is no, I am not aware of it. Yes.
Order that is passed by this court here, how will it stop the courts at?
No, that is a different thing. That's a different thing. It is a question of jurisdiction. the division bench of this court has taken a decision. I'll place that before the court. All I'm trying to say is that let there be an interim protection. I don't want conflict of laws. Here is a child is being torn between the mother and the father. My ladyship, can it be taken up at least tomorrow? At least tomorrow. Office objections, sir.
Your Lordship, this matter pertains to the year 2023, Your Lordship. 2023, Your Lordship, I am for the respondents, Your Lordship. The matter, the MC petition was stayed in December 2023, Your Lordship. The matter was listed in April. Your Lordship, it may kindly be had on Thursday or Friday, Your Lordship.
My lordship,
Already, there are about every day, there are about 52 matters on board. Yes, next.
Your Lordship,
my
any day
lordship,
before the
this
vacation.
trial court has set aside the temporary injunction.
In this matter, my honor, the petition has been dismissed for non-prosecution. The petition has been dismissed for non-prosecution, and a warrant, attachment of warrant has been issued. On 20th June 2023.
My lordship, I'm for
If it can be taken up tomorrow, my lord. We have filed for recall application.
trial court has set aside the temporary injunction, so I'm filing this. Similar cases have been disposed. In the year 23.
So what is that now?
Actually, for the temporary. Okay.
What is that?
Actually, we need the injunctions.
50 days after it. Yes, for the rest.
For petitioner, my lord.
Same matter where your lordship said refer the parties to Nimansh. Lordship said directed for the matter to be listed today. My lord, it's not listed. May I request for tomorrow? My lord? Tomorrow.
For petitioner, fresh matter, in scrutiny stage, admission stage.
Page wise adjournment, page 1, serial number 1 and 2, page 1 and 2, page 2, 3 to 9, page 3, 10 to 17.
For serial number 10, madam. They have not given the memo of calculation, my lord.
Lord, we have served, my lord, it has been sent to them. Lord, since last 10 months, they have not paid, my lord, the interim maintenance.
My lords, we came on record on NOC Wakalat, my lord.
Serial number 17, my lordship. Serial number 17. I pay for respondent, my lordship. I have to file some list of documents. I pay for a week's accommodation. I have informed the applicants also, my lordship. 2 times, my lordship.
After respondent is under, the same is responding and after that. Effective post is not wrong, 23 9, intermodal manager, I will get. Also, the applicant absence, door representation of the respondent, post is not wrong, 4 9. So, not last occasion, that was not the ground.
Not the ground, my lordship. Please.
Serial number 20.
4, serial number 18 to 23,
23, my lord, appearing for the respondent. Senior is not well. There is a
serial number.
dengue suspect. Is not well. Dengue suspect. My senior has informed.
Respondent is under, the same is informed to the council for the applicant, post is matter after vacation. On 21st of October, if the intermodal is there located, it's sent in the next day of hearing.
Page number 5, serial number 24 to 31.
Millets, kindly Millets, serial number 30 Millets. I'm for the petitioner Millets. I'm not keeping well Millets. Also, certain documents needs to be put Millets. May I request for a week's time Millets?
Hello, sir.
Please Millets, I'm for the petitioner Millets.
Is it stay in your favor?
Sorry Millets, not audible Millets.
In your favor, Mr.
Council.
Please, Millards, now it's audible, Millards.
Stay is there in your favor. In the RPFC, there is any stay.
No, Millards, there is no stay, Millards.
Was this matter on December 16th at the request of learned counsel for the petitioner? Yes, next.
Grateful, Millards.
Yes.
Page number 6, serial number 32 to 36, page 7, 37 to 40, page 8, 41 to 40. Serial number 41.
Look at the, yes, 41. Yes, we'll see and then we'll grant. Yes.
Number 2, serial number 1 and 2. Number 1, page 1, serial number 1. Ramesh Kumar.
Kindly pass out.
Pass over. Yes, next.
Number 2, Samir Esen, petitioner. Samir Esen.
Look at it. Interim order is there. On the last occasion, when the matter came up, that's on 13/8/2024. There is no representation on behalf of the petitioner, on behalf of both the parties. Post this matter, given today also, there is no representation. Post this matter for discussion tomorrow. Yes,
Serial number 3.
yes.
Your Lordship, the Honorable Trial Court has passed an medical expenses of lump sum of 90,000 rupees without only on the basis of the memo produced by the petitioner. So not opportunity given to me.
Please come to the order.
Yes, my lord. It's annexure A, page 9, in page 9.
Notice to the respondents.
Okay.
4,
Post after the registry is directed to issue notice, post after vacation.
serial number 3, Deepashri.
Serial number 3.
I 3 name.
4.
4, V. Vachan.
Lord, the husband petitioner is in challenge before this honorable court as against the order on IA number 22 dated 25/4/24. IA number 22, my lord, was filed by me seeking a direction from the learned trial judge to the respondent wife to produce her income tax returns and Form 26AS, because in her earlier interim application seeking interim maintenance was dismissed on the ground that she was already gainfully employed. Therefore, my lord, she again filed this application IA number 19 and 20 saying that she has resigned from her current employment. Therefore, my lord, I filed an application IA number 22. That IA number 22 has been dismissed by the learned trial judge, my lord. The order impugns starts at page 17, my lord, annexure A. This is an order, my lord, which several applications have been disposed of. The relevant application, my lord, IA number 22, page number 22, my lord, the discussion starts at para 11. The learned count, I'm sorry, my lord, my request, lordship, to come to page number 21, my lord, para number 8. In support of IA number 22, the petitioner has sworn to an affidavit stating that the respondent is getting income, and to ascertain her income, documents are required, and therefore he is prayed to allow IA number 22.
You're asking something as mandated by the apex court in Rashish versus Neha?
Yes, my lord. That is dismissed.
Yes.
And lordship may kindly come to page number 22, para 11. The learned counsel for the respondent has filed objection to IA number 22, contending that the application is not maintainable and it's filed only with an intention to track the proceedings. Now the respondent is not working and she's resigned her job and she's not having any source of income, and decide IA numbers 19 and 20. Income tax returns and Form number 26AS are not required. Therefore, the respondent
When
has
is the application filed?
My lord, the application is at page number 97. My lord, I filed the application on
Not this application, maintenance.
27/7/2022.
27/7/2022.
2022.
As per the judgment of the apex court, what are to be filed?
Filed a memo with the-
IT returns, forms.
Or from which year to which year? Give the judgment. Rashish versus Neha.
Page number 60, my lord, if I may request. Point number J.
Page number?
60, my lord, in my the journal, my lord, which I have. Point number J, my lord. Information provided by the deponent with respect to the income, assets, and liabilities of the other spouse. Then, my lords, K, details of the applicant or other spouse in case party is not so on.
1 minute. Which para of the judgment is?
My lord, enclosure 1, my lord, which is part of the judgment, my lord. Enclosure 1 starts at page 57, my lord. Affidavit of assets and liabilities for non-agrarian deponents. Here they are non-agrarian deponents. There is several heads, my lord, of information sought: personal information, details of legal proceedings, details of independent family members. Sorry, my lord, it's page 56, my lord. Sorry, page 57.
One, two, and three.
Several information details are sought, my lord. So that, my lord, the adjudication happens properly. That's all, my lord.
No, in the judgment, it is the, 1 year prior to, that's what, or 3 years prior to something is, it's mentioned there. Which para of it, I'm just looking at it. It is that enclosures are with regard to what are the information, with regard to the bank statements, and also there is a.
It's all included, my lord. Just if it's employed, what is the income that is being derived? What are the assets
How
held?
many years? Prior to the marriage and before filing application, that's how it is.
Through and through, my lord.
discussed.
In this case, my lord, through and through the respondent is
No,
employed.
no, no. First of all, let's see, where is that? Where did the apex court say that?
I'm sorry, my lord. I'll just assist.
You're seeking income tax returns from which year?
My lords, from from 2019-20, my lord.
2019?
19-20, 20-21, and 21-22. And Form 26 for the like period. Because the application is dated, my lord, 2022.
And this is filed in the year 2022.
Yes, my lord. The application was filed on 6/9/2022.
It is 3 years, I think, as per the judgment.
Just 3 years.
3 years prior to filing of the application. Then in that case, what is wrong with it?
Because of, I'm resigned on 23rd.
Might be, you might have resigned, but that should have been placed before the court. Why not?
Because I am not filing any returns of my resignation
Then
of
you
my
should
job.
tell the court that I am not filing.
I already filed.
Nil returns. Where did you say so? Not necessary, not relevant. That's how you said so.
The reason why, my lord, we have a doubt in the matter is that in the earlier round of litigation, my lord,
You just say not required. You didn't say that you don't have.
Because of, I'm the.
Then file an affidavit to that effect.
I'm ready to file
That there are nil returns, I have not filed.
Not filed.
May I just
So
say this,
because
my
of
lord?
23rd 8, 2021.
Yes,
my lord, is that?
That has been accepted by the employer on 2010-2021.
The earlier round of litigation, my lord, where their interim application was dismissed, it was challenged before your lordships. And that application was that petition was withdrawn. Kindly come to the order dated 79 as to what they say, my lord, in the said withdrawal.
70?
79, page number annexure F. Dated 6/6/2022. May I request your lordships to come to page 81, my lord, ink page 81.
Yes.
I'll read from the second line, my lord, the relevant part. Learned counsel for the petitioner, that's a respondent here in my lord, would submit that the applications IA number 7 and 11 filed under section 24 of the Act for monthly maintenance as well as educational expenses was filed when the petitioner was employed. But it is stated that at present the petitioner is unemployed as she was removed from her employment. This is what she says, my lord. Now, my lord, in the affidavit which she files along with the application seeking maintenance, lordship will get it at page 83. Kindly see the reasons, my lord. Page number 83. The relevant para, my lord, is at page 88. I read para number 8 from page number 88, my lord.
It's an application of 2014. It's filed on 27/7/2022.
Yes, my lord. IA number 19 filed on 27/7/22. In support of the application, my lord, the affidavit, my lord, kindly come to page number ink page 88, para number 8. There, my lord, the reason given was that she was terminated. Now, kindly see here, my lord. I stated at the time of filing the IA number 7 and 11, I'm working in Entity Data Global Delivery Services Private Limited. Now, due to my son's education and other circumstances, I gave resignation to the above said company. There, my lord, she says that she was removed from the employment. Now, here, my lord, in just a few months
Relieved
later,
from services on 21/10/2021. Then you were working in 19 and 2021.
But in 1920, I have not filed any returns because of the company has been deducting my income tax and they're going to.
That will also be there. If it is, if there is a deduction at source, it should be reflected. Your payment slips, whatever that is the
Already,
material you have to file.
I'll produce my payment slips before the trial.
Yes. Please come.
Also, my resignation has been accepted by the company. On
That
27th.
not before this court, before the trial court, produce everything.
Because of already the matters was posted on IA number 19 and 20. the
19
posted
and
for orders.
20, my lord, for maintenance was heard on the last week.
It's relevant for that, for
So
granting maintenance.
it's posted for orders on IA number
This is also relevant.
For
And
produce-
also about your, what are whether the statement that are made before the court or correct statements
Still
or not?
employment of that
About the
company has been
conduct of the
deducting my
wife.
income taxes and the
Uh-huh.
company has been filing returns.
What is that?
The company has been deducting my income taxes amount. They are going to file, the company is going to the returns.
Hmm.
After the
No.
after resignation, I have not filed
No.
my returns.
This application is filed in the year 2022.
22.
Yes, my
Is
lord.
it your case that she's working in 2022?
Yes, my
No,
lord.
she was in 2022, she was not working.
My lord, our case, my lord, is that she was working for the reason, my lord, because in June, she says that she was terminated. In July, when she files an application before the learned trial judge, she says that she has voluntarily resigned. My lord, this dual stand taken by the respondent, my lord, throws some doubt in the mind of the petitioner. We are not shying away from paying maintenance, my lord, to the child. We will pay the maintenance. If there's anything due, my lord, we will undertake to pay. We will pay. We are bound by the orders of the government. He is the father, he should pay. But it is not about that, my lord. It's about not willing to provide information to the court for the purposes of adjudication, my lord. There is no reason as to why that information has to be withheld. As your lordships rightly pointed out, even if no income tax is paid, once an income tax assessee becomes an assessee under the Income Tax Act, they are liable to even file nil returns. So there's no way, my lord, that the income tax returns would not have been filed. So this, my lord, this hesitancy in producing the documents, my lord, throws a lot of doubt in the mind of the petitioner, my lord. Therefore, my lord, we are requesting for an indulgence from your lordships. Let if there's no income, let that item.
When the court had, when the application is filed in the year 2022.
Please, my lord.
When did you file this IA?
Immediately, my lord, IA filed on 6/9/22, my lord. July 22, the maintenance application was
That
filed.
application is disposed of now.
Now, my lord, if initially the trial judge first disposed of IA number 22, the maintenance application was kept pending. Now, my lord, after filing the writ petition, the maintenance application has been heard and posted on 14/10 for orders. We informed the learned trial judge that the writ petition has been filed. The learned trial judge told us that if at all, if there is any interim
No,
order
this
passed.
order is also filed, it's passed long back. It's in the month of April. Why were you waiting till now?
My lord, we filed it in
Last
30th
4 months, they have
August.
not filed any returns.
We filed it on.
Till 4 months, they have not filed any application.
Why you have not?
My lord, there is some delay in approaching because, my lord, we were under the impression, my lord, that all the applications are argued. It was felt, my lord, that there will be an application order passed.
No, you cannot.
Starting hearing on IA number
My lord,
19 and 20, they have
What
filed writ
happens
petition
is
before
so
this
that,
order.
that IA is already reserved.
No, it is.
Already
My
posted
lord,
for
what we
orders.
were told, my lord, the matter was reserved last week. If my instructions are right, I'll stand corrected if my learned friend tells otherwise. When we informed the learned trial judge, my lord, that we have already filed a writ petition, that was in 30th August
So
2024.
filing
and
a writ
awaiting-
petition is not a ground for the learned judge.
Correct, my lord, correct.
Keep that
Yes, my
application
lord.
pending.
Yes, my lord. I
Unless
stand-
and until there is an order by this court.
I stand.
You
stand.
yourself have waited for 3 months
My lord,
so that the proceedings go on further.
No,
And at this point of time, why should the court stop everything and, everything should be, put, the clock should be put back now.
Lord, if I may respectfully submit this, the lordship is absolutely correct when your lordship says that there's a delay on my part in coming to this honorable court. My lordship may kindly appreciate that that fact, my lord, might not come to the aid of the respondent for the simple reason, my lord, that they are saying two different kinds of things before this honorable court. They are trying to evade the proper adjudication before the trial court. Lordship may kindly show me indulgence in the matter. Otherwise, also, my lord, as per the directions of the honorable Supreme Court, every person who seeks a maintenance has to
The
come
matter
before
will be shuttling.
my lord.
Shuttling between High Court and
Lord, in
the
fact,
family
Lord,
court like this.
In fact, my
When
lord,
there is no, why can't it, and when you are pursuing the litigation,
yes,
when you can file the applications, when an order is passed, why can't you question it?
Lord, we
We cannot say that there are lapses, tooth and nail, both of you are fighting with one after the other, one application after the, when will the litigation will attain finality with
Lord,
these kind of applications?
my learned friend will possibly support me in this. Several times I have myself suggested to my learned friend that let there be some reproachment in the matter because I have been litigating from the last 9 years. They have lead separately, in which I am personally aware, they have lead separately for the last 12 years. I requested my learned friend that if some mediation can be
What
done.
is the maintenance that she sought for?
No, my lord, she's asking for a maintenance of 50,000 rupees, litigation expenses of 50,000 rupees, along with
Maintenance of
75,000 rupees per month.
75,000 maintenance and 50,000 litigation expenses.
litigation expenses.
Education expenses.
And my lord, this is apart from the educational expenses, which I'm already paying to the son, my lord.
You are bearing the entire education
50% of the IN number 11 order was passed, directing me to pay 50% of the educational expenses that which we are paying, my lord. It is their contention that I have not paid. I am remitting the amount directly in the name of the minor, my lord, who has got an account in his name, where the mother is the sole operator of the account. Let them, my lord, produce a bank statement to show that I have not paid any amount. Or if there is any shortfall, my lord, we'll pay it because it is for my own son, my lord. I am not stepping back. But my lord, my holistically, if I were to say this, my lord, I am personally aware of this matter, having been the husband and wife having lived separated from the last 12 years, my lord. My learned friend also will say. And my lord, they are all both educated. They can lead their life. Now, some sense can prevail. I'll also instruct my client. Some sense can prevail. Let there be some closure to the litigation because there's multi-level litigations which
Who
are
filed
happening.
the MC?
MC is filed by me on the grounds of cruelty, my lord. They have filed a petition for restriction of conjugal rights. Much
So you are
further
ready to
as,
take her back.
no, my lord.
That is the settlement you are.
Mentally, my lord, they have moved away. If I may, I'm sorry, my lord, that I'm saying this because I had a word with I've always had a word with the petitioner, my lord, because I've known him. And mentally, my lord, they have moved apart. That, my lord, is what I'm instructed to say. But then, my lord, what I'm really saying, my lord, is that this kind of litigation, my lord, trying to have a matter
What is the
adjudicated.
age of the boy or the girl?
My lord,
Child,
my lord, is 11 years old. He's in the 6th standard. He was born in 2012, sometime in the end of 2012. He would possibly be 12 by the end of this year. And my lord, since from the time they have lived separately, they have not been able to see eye to eye. There's too much of vengeance and anger between them. I've been trying to tell my client that this is not going to be asking everything to be adjudicated before the honorable court when things have to be settled. My lord, there's no end to it. And we are still in the learned trial before the trial court. We have not even, my lord, I do not know what will happen either this way or that way, my lord.
By the time you come to the court, the high court, it's a long way.
It's a long way, my lord. And where are we going, my lord, with this? Now, I sincerely ask myself, my lord, where are we going with this?
Client is ready to join with the petitioners.
So that's what he's saying. From 12 years, both of you are.
We are making
till he
effort
takes
to
you
because
back,
of
you will be fighting.
Yeah.
When you know that there is no scope of reunion.
there is a chances of scope of union for the rejoinment.
Huh?
There is a scope of joining rejoin. The client is willing to join the
Client
petitioners.
is, it's not the scope is from your side.
Yes.
If they are not interested, why the client is fighting to 12 years? 12
Right.
years is a long period.
Client is not ready to willing to give the divorce.
My lord, it is, and anyhow, it was, and I've always told my learned friend, he's been kind to hear me out. And he also says that they should settle the matter. But for some reason, my lord, the parties are unwilling to see eye to eye. But I understand, my lord, they hate each other, but to drag each other down into the murky waters is something that I don't understand. I don't know. And we are compelled to make such kind of an argument, my lord, getting into the nitty-gritties. The fact remains, my lord, that rapprochement looks to be very far away.
But anyhow, what to do then?
Because of already filed a petition before the court, at the time of filing the memo itself, and the change of circumstances itself, I withdraw the petitions to liberty to seek the permission of the court to.
Whatever that is, file before the court, we'll see.
Please.
So again, opening that, what is happening before the court,
Please.
it's posted for orders. Will, whatever you have by way of a memo, serve them and file before this court what they are asking.
Please, ma'am.
The learned counsel for the respondent shall file before this court the income tax returns for the income tax returns for the year 2019, 2019 or 18.
19.
2019, 20, 20, 21, 20, 21 till 21 you're asking.
21, 22, my lord.
21, 22. From 19 to 22.
Please.
The income tax returns shall be placed before the court so that instead of reopening everything, well, if the court finds anything, then we will
My lord, the matter
ask
is
the court.
posted for orders on 14/10, my lord.
14?
10. A long date was given
Day
so
after
that.
tomorrow.
Please.
Day after tomorrow.
Please, my lord.
Yes.
My lord, may I request? I'm sorry, my lord, if I don't know if my learned friend agree. I'll keep my client present, my lord, on Wednesday.
I was ready to keep the client.
And if your lordships could kindly show some indulgence and advise the parties.
As a
to see if
petitioner,
they
also
can-
practicing advocate.
Only, my lord, is a member of the bar. And my learned friend's client was also a well-educated lady. And some reproachment can be shown by either of them. Some remorse, some soothing of their egos. Possibly they can free each other from this agony. I'll
Anita,
keep them present.
Wednesday, is there any matter?
In chamber.
Not there? Yes, let the matter be listed day after tomorrow at 5 o'clock in the
26th, my lord.
chambers.
Kindly post, madam. 26th, madam. Kindly list on 26th.
26.
Yes.
It is, any matter is there on 26? 26 is Thursday. 26 it's not possible. It's only on 25th. 25th.
5 o'clock.
25th, 5 o'clock. Yes, next.
My lord, in that, will the matter be listed because I'm seeking for an interim order because on that day there's no hearing, my lord.
No, no, it will be body. Order will also be passed in the chambers itself.
Please
Basing
oblige.
on what?
Greatly oblige.
Yes.
Serial number 5, Adi Narayanappa for petitioner.
On that day, both the parties shall be present before the chamber. Yes.
The petitioner is challenging the interim order passed with
What is the interim order?
the maintenance of rupees 15,000
1,000 granted to the wife.
wife,
You are for the husband.
husband.
What is your income?
I am an agriculture laborer. May kindly see the ink page 24 at para 15.
Please come to para 16.
With reference to the income details of the respondent, he has shown that he is not working. He has a home loan of 10 lakhs 21,000 in column number 1. He shows his profession as a daily agriculture labor and getting income of rupees 10,000. With reference to the petitioner income, he has shown that the petitioner is working as an accountant and earning
You are a daily laborer and you have a home loan of 10 lakh 21,000.
I am a husband, agriculture laborer. My wife is working. I am stating that she is.
Who has home loan of rupees 10 lakh 21,000?
I am having.
How much is your EMI per month?
That I have produced the statement of account and it shows.
No.
My
10 lakh 21,090 of your loan, how much would be the monthly EMI? And the laborer, how much is earning? That the court wants
my
to know.
father having a 5 acres of agricultural land, out of which they were earning.
Please place your statement of assets and liabilities, then we will pass some order. Close this matter after tomorrow.
I have produced.
Filed along with this?
Yes, yes. ma'am.
Page number?
Page number, my assets and liabilities, I have produced at annexure. Liabilities of the petitioner.
Let's see.
Annexure H. madam.
So you are incurring an amount of rupees 10,000 towards the dependent, agriculture laborer.
Agriculture labor.
For your dependent, you will pay 10,000. Please come to page number 71. It is your statement, Vinay.
The expenses,
71.
family expenses I
No,
require.
no. What it says is the approximate expenses incurred on account of the dependents, 10,000.
10,000.
So you are spending for your dependents 10,000.
Yes, ma'am.
Yes. Next.
Home line details at column 6 at 74.
You are
Assets
paying
and-
EMI, you are paying 17,746 as EMI, 10,000 towards your dependents. So 27,746 is as it is without any other expenses. You are showing agriculture, you are a laborer.
Agriculture labor and my parents having agriculture land to the extent of 5 acres.
What is your income? Why did you say? As an
Yeah, it is
agriculture
the,
laborer, how
agriculture-
much your net income from the business profession partnership? 10,000. If from 5 acres of land, how much your, what is the income? Let's see.
It is discussed in the para 15. 2,50,000 annually I am getting income.
For 5 acres, you are getting 2,50,000.
50,000.
So 2,50,000 annually means per month how much?
20,000.
Hmm?
20,000.
How can it be?
12, 20 by 12,
20,000 per month.
20,000 per month.
In that
17
20,000 per month, already, you are already paying 27,746.
10,000, it is in a
That
family
is-
expenses and
Family dependents, you are paying 10,000. 17,746, you are paying towards your EMI.
Yeah.
It comes to 27,746. So if that 20,000 for your 10,000 you are earning will become 30,000. So remaining amount is 3,000 and odd. In 3,000 rupees, how will you live? Please don't, this is not the way you give your statement for the purpose of say not to pay, for not paying maintenance. Will notice to the respondent.
And no, 10,000 may kindly be passed. 15,000 it is awarded. She is a BCom graduate, I am a PhD paid.
See, whatever the reasons you're saying, whether they are reasonable or not, I can understand if you say, my wife is earning, that's why she is not entitled, it's a different aspect. I'm agriculture coolie. Now, 10,000, when was the petition filed?
It is filed in the 2000. 1 second. This month, 2024 only, 23, 4/7/23.
4/7?
23,
14 months,
yes.
1,40,000 arrears. Then cost for the petitioner submits that the wife is earning 30,000, is working as agriculture, is working as a coolie. These aspects were not considered by the court, and court had granted maintenance of an amount of rupees 15,000. Considering the submission of the land counts for the petition, they shall be stay of all further proceedings on the condition that he shall continue to pay an amount of rupees 10,000 by 5th of every succeeding month, and the arrears are 10,000 per 14 months at 1,40,000. The 1,40,000 shall be deposited within 4 weeks from the date of receipt of the copy of the order. Either for 10,000 is not paid by 5th of every succeeding month, or the arrears are not deposited. The stay granted by this court stands vacated without further reference to the court. Same noted the hand summons to the counsel appearing for the respondent before the trial court, and shall file a memo to that effect by 14th of October. If the same is filed, list this matter on 15th. Yes, next.
Then we ask for petitioner.
My lord, the mother of the minor is a petitioner here, my lord. What is in impugned is Annexure G order, which
Page
rejects
number?
on page number.
Page number?
Yes, ma'am. Page number 153.
Yes.
This is a petition filed by the petitioner objecting to the jurisdiction of the family court under Section 9 of the Guardian and Wards Act. I will not briefly state the facts because they're very.
Let me look at what is ordered, then you
yes,
can.
Yes, ma'am. Shall I read, my lord? The reasons. Next page, page 154.
You're the mother or the father?
Yes, mother.
You
I'm
are
the mother.
You are the mother.
I'm
Who
the-
filed the GNWC?
The father. The child was abducted from USA, where he was ordinarily residing with the family, without the consent of the mother or of the child, and brought to India under the pretext of considering some homam, religious ceremony for the son.
And files a petition here.
Not by the father, the respondent father.
Files a petition here.
He files a petition here.
He's also working there.
He was working in the US. They're all green card holders.
Of India or USA, the boy?
The boy is citizen of India, but he is a green card holder in USA, studying in USA.
What is the age of the boy?
Now when he was brought here, he was aged 9 years. Then in 2019, he was brought here. And my lord, there is a history of litigation because there was an order by the.
Order passed.
This order was passed. Well, I'll explain. But I have come on record only after last 2 months as counsel.
This is also a case where notice has to.
Yes, I understand.
Notice to the respondent.
Yes, but
petition, permitted
well,
state
now, my lord, the factual matrix has been All disputed facts, the court says admitted facts because the entire
Petition, what is he doing? What is she doing without questioning it from 2020?
my lord, her counsel never advised her, my lord, unfortunately. Now, my only limited prayer is that this may be framed as an issue for trial, that's all. Now the matter is proceeding for trial.
Them come.
Yes, madam.
The notice petition is permitted to take out handsomens on the counsel appearing for the respondent
Yes.
for the trial court and shall file a memo to that effect by 16th of October. If the memo is filed, post list this matter on 21st of October.
Yes, madam.
Yes, next.
Case number 7. K. Ravi Shankar.
Petition.
Yes.
It's husband's petition. Last may turn to your lordship's order in page number 143,
143.
please.
Hmm.
Annexure K1.
Hmm.
But your last may recollect.
Hmm.
Can,
That is a pending matter. No, another litigation on that.
now, your lordships have said, since the para 8, ink page number
I
1.
remember, I remember. What is the order now?
No, no, not the order. I am challenging the whole proceedings on the ground that since 28 lakhs have been granted. Last me recollect, we have filed an MFA, they have also filed an MFA granting diverse. I have challenged the quantum. 7 lakhs have been deposited. No efforts for filing an application for releasing further more amount or nothing
What
has
is
been
so
done.
discussed in this?
Your lordships have discussed
Hmm.
and dismissed on the writ petition on the ground that the application for 127 is not maintainable since there is no maintenance order has been granted under section 125 interim maintenance. It is on that score, this court has dismissed the writ petition, given a liberty, in page number 151. Now I am before challenging the very proceedings that your lordship may have also gone through the Rakesh Malhotra that can't be allowed at all.
This application that is filed by her is much prior to
No, whatever the
the
reason.
judgment and decree that is passed.
The proceedings, as of now, it is still pending consideration.
Hmm.
The proceedings, as of now, under the 125 is still pending consideration.
Yes.
But now the decree has been granted. Now, the pursuing the 125 does not arise now, as of now.
Notice to the respondent.
But I have sought for the stay because the proceedings are not set down for evidence. I cannot be allowed to dual standard. Double maintenance.
Then where is the order?
The order sheet depicts. You kindly see the order sheet
Have you
annexure.
moved such an application before the court saying that it is not maintainable?
That has been filed under section 127. Then your lordships have said.
Correct. No.
Correct.
Whatever you are seeking before the court, you should tell the court.
But I cannot say because the proceedings cannot be terminated by the trial court. The proceeding will have to be terminated under the.
On the maintainability is always the court can consider. Once an application is filed, it's for the court to see, it's for you to say whether such an application is maintainable or not. And if the court do not consider.
I will be back to square on the same footing when the application under section 27 is rejected.
This is not a jurisdiction under 226. We are exercising
It's a-
227.
Yes, Milord. Your lordship may kindly have a look at this judgment squarely covers. Only for the moment, your lordships have already gone through.
Yes. No, when order is passed, when is the order passed by this court?
This court
is
has
all-
been granted 2020.
No. The other writ petition which this court held that it's not.
This
maintainable.
court has held Milord on recently. On 16th July 2024.
Hmm.
July. Now we are in September.
Hmm.
That is why I filed 482, then it is got converted because the 482.
Then how many times the court has heard this, how many times it has come up pursuant to the order passed by this court?
Only 2 times. Annexure F is the order sheet. Kindly turn to page 86. Await orders. Only 1 time it has come. It is not that I have.
No, you can't anticipate that the trial court will pass an order so that again I have to come to the high court. So let me straight away go to the high court.
No, my apprehension is this. But if the application for a maintainability is also been dismissed, kindly have a situation, I will antagonize myself. Then when the application itself, it is not maintainable, I will be the same position as could be the order passed under section 127.
But a procedure requires that you have to
The
pass
trial,
through the procedure.
the trial court cannot terminate the proceedings. It is only
Not
the High
terminating
Court.
the proceedings. When a petition is filed, when the
Yes.
respondent says that such an application is not maintainable, the court has to look into it.
But I am also saying before this court, let them give.
And that court, before whom you are there, before the proceedings are pending, why should that procedure be bypassed and come to the High Court? Then you will have an opportunity before this court to say that what is said by the court, what is the conclusion arrived by the court is wrong.
But in that regard, even the windows are open in the Rakesh Malhotra, the Supreme Court said, treat the application under Section 25.
Supreme Court, what Supreme Court said, the ratio, Supreme Court will never say straight away go to the High Court.
No, I'm not on that point.
Supreme Court has only said, so when the pending alimony and other things are pending, so why should
I have to file an application, I get rejected, once again come, once again move.
But that's unfortunately, no, you can't straight away come to the High Court and file a.
But I can also come approach.
Instead of permanently 5 years standing there straight away, let this court pass an order, so that then I'll go to the Supreme Court.
See a situation where you lost.
No, we'll be setting a very bad precedent.
No. I'm only, you lost me, kindly have a look at a paragraph.
I understand. You have a judgment in your favor. The same can be placed before the trial court, saying that this is what the honorable
Now
not able to appreciate. If a particular application is not maintainable before the court, on that ground, if an application is filed by the respondent, bringing all the facts to the notice of the court, it's a duty of the court to consider the same and pass orders. Instead of coming before this court, whatever are the grounds that are raised before the court, the petitioner ought to have raised the same before the trial court. When counsel submits that, instead of relegating the parties to the trial court, the same can be appreciated, the same can be decided by this court. On that submission also, this court is not able to consider and appreciate. Hence, this writ petition is disposed of, giving liberty to the petitioner to raise all the grounds before the appropriate court accordingly. Writ petition is disposed of.
This cell number 8,
Public.
Yes.
my SK.
For husbands.
Yes.
Plus marriage has taken place.
What is
13
the
years
order?
back. Plus order is issue notice on the application that is filed for rejection of the petition, because the Bangalore court has no jurisdiction at all. Child stays in Pune, parents also were in.
So no interim order is passed.
No interim order. Plus my difficulty is, since this is posted to 1910, now he cannot subject himself to this jurisdiction and even ask for visitation rights. So if I may be permitted to serve the counsel before the family court, maybe there is this thing for at least Dasara, because the child is extremely close to the father.
No, like this manner, there is no visitation, nothing is pending before the court. No order is passed.
GNWC is pending.
GNWC is pending. You have not moved any application.
I have moved an application.
When did you move an application?
On 2nd of September.
2nd of
September.
Notice has to go to the respondent.
No, they have filed. She has filed a custody petition here, my lords. She has brought the child in April, all of a sudden, without the knowledge of the father.
Who has filed the application that the court has no jurisdiction?
I have filed.
You
The
filed
father has
it.
filed. Yes.
Court has ordered notice. When the court.
No, it's not notice. Court had ordered for objections by the petitioner.
It has to be. It has to be.
My this thing is, let us
It is like this. You can't have both. You tell the court that you don't have jurisdiction and give me an order.
No, Milas, I'll just 2 minutes, Milas. Now, all the three were staying there. Suddenly, April, she brings the child and comes
I
here.
understand.
Yes.
GNWC is filed by the wife.
Yes, GNWC is filed.
Saying that before the courts at Bangalore.
Yes, the
It's
court does
your
not have-
case, it's your case that the courts have no jurisdiction.
Correct, yes.
And at the same time, you say, you pass an order of visitation in my favor.
I have not filed an
No,
application.
that's
for
what you're
visitation.
saying now before this court.
No, only this court has that power where if the council appears and if they're willing to send the child for
When
2-3 days.
an order, no, when you yourself, if that's the case, you should have asked for visitation first. Then you should have filed an application saying that.
No,
the
my
court
lord,
has-
I can't subject myself to this jurisdiction.
Then in that
And then,
case,
like your
in that
lordship
case,
said,
wherever is the jurisdiction, go before that court and ask for visitation. You
but
can't.
at least let there be direction that this application be decided fast, my lords.
No, that can't.
Because this has to go.
September, the court has its own board, the present
I understand
petition is
September it's
filed.
not possible considering that, plus at least.
Will not will, unless, the kind of indulgence, what is required can be. not
Ultimately,
in
the
every-
petition has to be allowed because 1910.
No, because, you see, for your client, there is urgency that is, application at earliest should be decided. All the matters that are pending before the family courts or the GNWC courts, everybody has the same urgency.
Milord, the child is missing the school. She's already admitted in Pune. That is the difficulty.
But no, the court cannot pass any order when it has no jurisdiction.
The court has taken jurisdiction. That is the reason I'm submitting before this court. Plus, what
When you
has
filed an
happened is-
application, court assumed that it has jurisdiction and that's how it is numbered.
Correct.
Now you file a petition that court has no
Application.
jurisdiction.
I filed an application saying that
Whatever
there's
it
no
is.
jurisdiction.
So then the court has to decide it that that it has no jurisdiction.
Yes, but it is posted to 1910. Though I have brought it to the notice, the child is missing.
That's
from
a
the
minimum
school.
time. September is that. Then
Not
it's a
September,
October.
1910.
October. It will.
Plus,
The
I
1 month
filed
time.
it on
Won't
2nd.
you require a 1 month's time? The court minimum.
I filed it on 2nd of September and the child is already missing 3 months of school. And she's doing extremely well in a school in
Let it be.
Pune.
Let it be. What to do with these kind of things? We can't tell the court to do out of the way everything. There are so
Milord-
many other matters pending.
Milord's objections to the application could have at least a hot date, maybe may
It
have
is
been.
minimum 2 weeks, 3 weeks, even
Yes, correct. Minimum 2
weeks.
weeks, 3 weeks, but 1910, my lords.
When it it has
2nd
come up.
September, I filed.
The court must be having some other matters, that once you're
difficult-
before the court, if I can understand, court has given January or February, no, it's in October, it's a reasonable
My
time.
difficulty is the child is missing school in Pune.
But what to do, they disputes and it happens, what to do?
Then
the-
in that case, may I be permitted to withdraw the petition if your lordships are,
The writ petition is dismissed or withdrawn, yes, next.
I'll file, I'm grateful.
Number 9.
Then calls for the petition, seeks permission to withdraw, accordingly dismissed as withdrawn. Yes,
Number 9.
For the petitioner in this matter, my lord.
yes.
My lord, the impugned order is at page 46. It's a
Yeah.
GNWC petition. It is filed before the trial court. IA for restoration of custody to the mother came to be rejected. Vide order at page 46, my lord. 46, my lord. Page 46.
Yes.
Please, my lord. The relief sought is at the bottom of page 46. Direct respondent to produce minor child Maurya before court and restore custody of minor child to petitioner. Further, my lord, the reasoning is assigned at para 16 at page 63, where the honorable court holds petitioner has also prayed to direct respondent to produce child before court. For this, respondent
You have not
appears.
sought for any visitation, you sought for restoring the custody to the.
Please, my lord. However, visitation was granted, my lord. Weekly once visitation was granted. Subsequently, my lord, visitation is being exercised by the mother as well. She was subsequently summoned to the school, my lord. I have produced the letter which is issued by the school at page 191, where the school authorities intimated her that he is not performing well and he requires remedial classes. He doesn't seem to understand much of what is being said in class. That is what is elaborated in the letter produced, my lord.
From when
Further-
he is staying with the father?
My lord, November 10, 2023, she was asked to leave from the house and hence she proceeded to file an FIR.
Take notice, we will consider.
My lord, if I may just point out one aspect, my lord, I'm not pressing for interim relief of restoration of custody. However, my lord, because she was summoned from the school, parallelly she preferred an IA for weekend custody, my lord. Now that was heard by the Honorable Trial Court. At page 43, I've produced the order sheet of the trial court, my lord. What has happened is that because of this April 3rd order where temporary custody was rejected, restoration was rejected, the trial court holds that my predecessor has already passed an IA order. And in
That's not in question now.
please, my lord,
That's
I
not
have
in question.
challenged. My lord,
Not question that order, you have questioned the order where your application for restitution of custody is.
please, my lord, however, my interim relief, my lord, I'm seeking for weekend custody also. Nevertheless, my
In
lord,
these
may I
matters, the
request,
court will not pass any order without the presence of the other side.
my lord, since the trial
Petitioner.
court proceedings are listed tomorrow, if I may at least request for a direction to the trial court to proceed with the matter without being prejudiced by the reasons assigned
How
in
can
the
it
order.
be without notice to the other side and without understanding, without knowing what is their case is? The petition is
Then
permitted
may I
to take out
request for
notice on the.
tomorrow, my lord, trial court is also listed tomorrow. I'll take out hand summons on the advocate appearing in the trial court.
You are permitted to, but they have to count, they have to.
Please, I'll serve it on them, my lord. May I request for the matter to be listed tomorrow because she has sought for weekend custody and also vacation.
Unless and until they're here before the court, court will not pass any orders.
Please, my lord, I'll have it served immediately. If I may request for a date to be given tomorrow, I'll have them.
How do you expect them to engage an advocate by tomorrow?
There is an advocate appearing in the trial court. Plus, they have filed 482 petition challenging the 498A, my lord, where CC is filed.
Petitioner is permitted, counsel the petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to the defect post this matter on 1st of October.
Please, ma'am. Grateful.
Yes.
Srinath Kulkarni,
For the petitioner.
petitioner. Ramchandra Ji Bhatt, respondent.
Yes. You're for the wife.
Please.
What is the order of the trial court?
Lord, the order of the trial court, Lord, is to pay rupees 50,000 per month and to provide accommodation to her within 2 months from the date of the order that is on from 16/12/2021.
So 50,000 maintenance and also accommodation.
Please, my lord.
So what has happened?
My lord, from 16 to 2021, my lord, he has not provided me accommodation at all. My lord, I took, my lord, a rented house in Bangalore.
And what about the maintenance of 50?
Maintenance, my lord, from 11 months, my lord, he has not paid the maintenance, my lord.
Any interim order in this case?
No interim order.
Then why did you not file your execution?
I filed the execution. Lord, in the execution after great difficulty, my lord, he has been served and he appeared. My lord, took time for making payment of the balance amount. He did not do that. It is pending.
Who has filed the MC?
MC is filed by husband, my lord.
Then why don't you file an application to seeking stay of further proceedings?
I have already filed, my lord, that has been rejected by the trial court. Hating that,
Have you questioned it?
but I have to question that, my lord. Very recently, order has been passed.
Because that's the only relief the court can grant you. In his writ petition,
Not
court
the,
can't-
my family court says, my lord, since the matter is already pending before the Honorable High Court.
Hey, you come up with an application, you come up with that questionnaire, we will pass an order. If he is not, take your own time.
MC case is already for argument, my lords. It will be, there will
The
definitely be first.
petitioner
And memo of
seeks time
calculation, they have not
for
given.
filing the memo of calculation before this court. Learn counsel with the respondent submits that when he's not paying maintenance, nor he has provided a separate accommodation to her as per the order of the court. In fact, they have filed an application with the court seeking stay of proceedings till the maintenance is paid to the wife. That application is dismissed and they're going to file a writ petition questioning the same. Pose this matter after vacation on 14th of October. Yes, next.
Cell number 11.
In the meantime, my lord, I'll provide him the calculation also.
In the meantime, you have to file the
I've
calculation.
already filed in July, my lord. They say they have not received the
In the
copy.
submissions and counsel, the petitioner submits that the respondent is directed to file the calculation memo. Till now it is not filed. And counsel for the respondent
Already filed,
submits
ma'am.
that he has already served, and
On
again he will
70
serve a copy of it.
8/7/2024, I have filed.
Record, my lord. We are on NOC Wakalat. I don't know before that.
No, if it,
3 times, my lord,
no,
they have
everything
appeared.
will start from when you come. Your client, the file must have been written by the other counsel.
We did not received, my lord.
On
Let them
that
talk.
8/10, I have
That
already filed.
submission you can't make. In the meantime, counsel the respondent shall serve the calculation memo on the counsel for the petitioner. Yes.
Cell number 11. Sunil Shastri M. CG Malay for the respondent.
Petitioner, my lords.
Lords, I pray for the respondent. I pray for a short time, my lord.
Why is it listed today? At request of non-counsel, the petitioner poses matter, no further adjournments will be granted. Interim order earlier granted is extended. Now the respondent wants time.
Please.
Interim order earlier granted is extended until further orders. Pose this matter on 9th of December.
Cell number 12.
Appearing for the petitioner, my lord. Husband petition, my lord. Husband file a petition. Wife file a petition before the
Vidya, at the request of non-counsel, the respondents. Yes. In that other matter, yes.
Annexure A is the impugned order, my lord. Earlier, they filed an application before the DV Act, my lord. They are, that order was passed 4,000.
What is the maintenance granted in this court, in this case?
4,000, my lord. Earlier is also 4,000, my lord.
What is your income?
21,000, my lord. He's a private company. He's working in private company, my lord.
So now altogether the amount comes to 8,000.
Please, my lord.
You're earning 21,000.
21,000, my lord. His parents, old age parents is there, my lord. Mother is bedridden, my lord. He's taking care of that mother, my lord. Even petitioner is
Child is also there.
my lord.
Child is also there.
Child is also there.
So you can't pay 8,000 to your
Now,
child and.
now, my lord, he is ready to take the wife and children, my
That
lord.
will be
She is
decided,
not ready
that's
to
not the
come, my lord.
ground for, when your 24,000, 21,000 is your income, court has granted 8,000, that's reasonable.
But this is too highly impossible to pay that amount, my lord. At least 5,000 to 6,000 we can bear that amount, my lord. 28,000 is not affordable, my lord. Affordable to pay the maintenance for pay this petition.
Why not?
His
Only
parents,
8,000 for two people. What is the remaining amount?
parents, mother and father is there.
You have a wife and a son also.
But he is ready to take care of mother and wife and children, my lord. She is not ready, my lord. She is rented house in the Indra Nagar, my lord. She is not at all ready to come join with the petitioner house, my lord. She filed a petition for conjugal
Court is
rights,
not
my lord.
inclined to grant any order, better let the court adjourn it. Pose this matter after vacation.
Cell number 13.
Give a date on 12th of November at the request of non-counsel petitioner. Yes, next.
Cell number 13.
My lord, I am appearing for petitioner. My lord, in this case, my lord, the interim maintenance of rupees 20,000 has been granted by the trial court in favor of my son. I have been paying it. And the interim maintenance has been granted from the date of the petition. That comes to rupees 11,20,000. As per the directions given by your lordship, I have deposited 4 lakh. Later on, I have deposited 2 lakh. Totally 6 lakh I have deposited.
6 lakhs you have already deposited.
6 lakh I have deposited as per the direction given by your lordship. 6 lakh. So I go on paying rupees 20,000. I am having old age parents and also I am having aged grandmother. My humble request is that, my lord, the remaining amount of 5,20,000 that may be quashed, my lord. Remaining 5,20,000, that is the arrears of that is the award passed from the date of the application which has been filed in the year
What is
2000.
your income?
My lord, yes, I am earning, my lord, 65,000 per month.
No.
65,000, and my lord, it has come in the judge order itself that the respondent number 1 is also an employee and income tax payee. She has filed affidavit of assessed liabilities. I have not filed, my lord. The counsel before the trial court has not filed it. She has filed affidavit of assessed liabilities. So she is an income tax payee, and she is also
You are
earning.
ready to pay, you are ready to pay 20,000. That is.
Yes, my lord, I am
that is
ready to
not
pay.
disputed. And once
I have been
the
paying. I
maintenance
have been
is
paying.
granted, it has to be from the date of application.
Application that comes to rupees 11,20,000.
So at best, what the court can do is for this 5,20,000, if you want installment, we'll give you installment.
My lord, but then, my lord, I need a short accommodation because I am going to file. I am going to file my affidavit of assessed liabilities, my lord, because I have not filed it. Now, before your lordship, I will file it.
Can you
A short
yourself accept that it is 75,000 is your income?
my lord,
And
but
20,000 you are ready to pay. So,
my lord, I have been paying installments towards loan, my lord. It has just, I take your lordship kind attention to the order of the trial court, page number 32, my lord. Your lordship may kindly have a look. Even in the trial court order, the trial court has observed that I have been paying installment of rupees, total installment 65,000. And it has come in the order of the trial court itself that I am having loans.
if that's the case, how will you pay? Your salary is 75,000.
No.
65,000 towards installment.
My lord, I am unable to pay installments regularly. I am unable to pay installments regularly. So I am going to file affidavit.
And you have
of my
already
assessed
paid, as per the order of this court, 5,20,000.
6 lakh I have deposited, my lord. 6 lakh I have
6
deposited.
lakhs, 6 lakhs you have paid.
I am having aged parents.
So please come up, please get instructions. What is the installment he requires?
Yes, I will
So
file affidavit.
that
Short
amount.
accommodation.
Nothing else.
Short accommodation.
For this matter,
Obligement.
1st of October, at the request of land counsel, the petitioner, by the time he shall get specific instructions. Yes, next.
Cell number 14 for admission, Eera for ATM for appellant. Please not.
Vote is not ordered in respect of respondents. No representation for the appellant. Post for dismissal tomorrow. Yes, next.
Cell number 15
Pass over next, 16.
for 16.
I appear for the respondent, my lord.
Yes.
Under the ESI Act, not your lordship had called for records. I'm not sure whether the records have come and go through the records, my lord.
Not at all. I think on the previous occasion.
On
it was not
4/9,
called.
your lordship had called for records, my lord.
But it's only post this matter on 23/9. I think that is not recorded. The registry is directed to call for the records. Post this matter after vacation on November 12th.
Along with MFA 3549.
Post along with, you write it. down.
Please, madam.
Post along with so and
3549
so
of 2022.
on that day.
22. 35, 41, 40.
Cell number 17. TN Satyanarayan Shastri.
Yes.
They have not filed objection to my applications, both for interim order and also an application to produce additional documents. I request also kindly for admission. I request your lordship to kindly turn to.
There is no, we'll dispose it off.
I mean, records be called for.
For the respondent.
Records be called for because your lordship kindly appreciate.
the total property with regard to the identity and measurement is different. And the observation made by the trial court is to the extent of 10 guntas. But whereas the property which has been conveyed is only 6 guntas, excluding 4 guntas Karab. That is the observation made. That is evident from the document.
Property at
Okay,
all.
one
I
second,
can
sir,
place
please.
all
One
those
second,
facts.
sir. 1 second.
No, there is an order in your favor.
There is an order.
I can point out,
History is directed to call for the records, post this matter after vacation.
yeah, interim order may be extended.
Interim order is granted in this.
Status quo is ordered, Lord.
I am ready for arguments now itself.
I want to place certain facts before
One
this
minute,
court, Lord.
1 minute. When
Documents.
is the order passed? Status quo.
Your Lordship may kindly turn to page 31 of the interim
Court
order.
has not passed any order.
Let's,
I have not passed any order.
no, you are not. Interim order has been granted earlier. Stay.
Call for the trial court records for this matter on November 12th.
Interim order may kindly be.
Interim order earlier granted is extended till then.
Obliged, Your Lordship.
Serial number 18.
Yes.
Chintan Chinnappa.
My lords, respondent has been served, my lords, in this case.
Sir? Yes.
For the final hearing, maybe it will taken up after some days.
Why finally, if you argue,
My
we'll
lords,
hear.
arguing counsel is not here today.
The request of learned counsel for the appellant, pose this matter on 26th of November. Yes, next.
Serial number 19. Sheshadri.
The respondent.
Manmohan PN.
I pray for short accommodation.
You have an interim order in your favor?
No, madam.
Pose this matter tomorrow, no further short accommodation.
My lords, what is?
We'll grant stay and then post it after vacation.
We have a. My lords, it's a suit for specific performance.
It's his appeal. He has to have, this application has to be here, court has to hear his stay application.
We have
You
to file
can't stop the
objection.
court.
Next Monday, my lords. Maybe post it on.
Monday not
We have to
possible.
file-
Post tomorrow, no further adjournment at the request of the learned counsel for the respondent. Counsel for the petty appellant has opposed the same. Yes.
Serial number 20. Yadunandan N. For appellant.
Please, Your
Yes.
Lord, plaintiff's appeal, not one request. We have filed one application for injunction, not in this appeal on Saturday, month.
Oh, it's not listed now.
It is, whether it is listed, put up, it is not put up, madam, it appears.
Ministry is directed to put up the IA sought for injunction. Post this matter tomorrow.
Please.
21.
Serial number 21. Prince System D'Souza.
Wait, it's not is saying something and not audible. You're not audible, Mr. Counsel.
It's not. Twenty-one.
Come physically tomorrow. You're not audible. Just learned counsel appeared online. It's not audible. Post this matter tomorrow.
Serial number 22.
Yes.
KBS. For appellant.
Yes.
No, this is the plaintiff's appeal against the rejection of his interlocutory application or
Yes.
injunction. Lord, we pointed out
Shall
these.
you order notice in this to the respondent?
Please.
Mr. Khan? Notice to the respondent. Yes.
Serial number 23 adjourned.
This is directed to issue notice. Yes, next.
Serial number 23 adjourned 24. Venkatesh C. For appellant. Manu K.
Waiting for a pass over, my lords.
Yes, pass over next.
Please, my lords.
Serial number 25.
Same, my
It's also same. Yes. 26.
Serial number 26. Pradeep Kumar. For appellant. Vijay BN.
No representation. Hold this matter on 22nd of October.
Sale number 27. Tobita N. Shetty.
Same. On 26th of November.
November. 26th of November.
Yes.
Sale
No
number
representation in this matter. Yes.
28. Ramesh KR.
You for the respondent.
Number 124.
Interim order is there?
No.
No interim. No representation for the appellant. Poses matter on 12th of November.
Sale number 29.
Same matter. Same, no representation. Counsel for the respondent is present.
11. Sale number 30 adjourned. Sale number 31. Ravi HK. Ravi HK.
Same order. After vacation.
11.
Post the matter on 28th of October.
Hearing on interlocutory application, sale number 30, 32. Pawan Chandra Shetty.
Serial number 31.
31?
31.
31, call the matter.
Yes. 31.
Yes.
Lord, this is a matter where,
How much is the amount granted?
Lord, rupees 6,000 each to the mother and the son, my lord,
That's 12,000.
12,000. my lord.
What is the income of the husband?
Lord, the income of the husband is stated to be 60,000 rupees.
According to him,
Lord, according to him also 60,000.
then why can't he pay 12?
Lord, the dispute is with regard to the relationship itself.
Was it decided by the court?
That issue was not gone into, my lord. May I just draw my lord's kind attention to page number 25.
Relationship with whom? With the wife or
The
the paternity
relationship
of
with
the
the
child?
respondents, my lord.
Both the respondents.
Both the respondents. Admittedly, my lord, the petitioner herein is married to some other person in the year 1995 itself. That issue has been answered by the trial court in the affirmative. Therefore, my lord, few important points, my lord. Page number 25.
Let's read.
The petitioners have contended that petitioner number 1 is the wife and petitioner number 2 is the son of the respondent. According to the petitioners, the marriage of the petitioner number 1 with the respondent was performed according to Hindu customs and usage on 8/3/2005 at Sri Goravanahalli Lakshmi Temple, Korotagere Taluk, and said marriage was a love marriage and was performed in presence of Srimati Kempamma and Lakshmamma. Therefore, according to the respondent number 1, this marriage took place in the year 2005. Now, my lord may kindly turn to page number 29, para number 11.
This is filed with the petitioner they are referring to is the wife.
Yes,
Petitioner has contended that the wife and accordingly the marriage. has
married in
taken
the year
place.
2005. Now, kindly see page number 29, my lord.
We'll continue reading it so that we'll understand.
Yes, ma'am. Yes. It is also contended that at the time of marriage, the brother-in-law of the first petitioner, by name Kempanna, had given a cash of rupees 25,000 to the respondent and had given golden ornaments to the petitioner number 1. This contention of the petitioners is also totally denied by the respondent. On the other hand, respondent has denied the relationship with the petitioners and contended that petitioners are strangers to him. Petitioner number 1 examined herself as PW1 by way of filing affidavit, has reiterated the petition averment.
Come to para 11.
Para 11. In this background, I have gone through the documentary evidence adduced by the parties, which may help the court to ascertain the relationship between the parties. Exhibit R1 to 4, 6 to 30, 15 to 17 shows that respondent had married one Bhagyamma on 1/6/1995 itself. Above document shows that respondent and said Srimati Bhagyamma are the legally wedded husband and wife. Said documents also shows that respondent through Bhagyamma had two sons, Harish N, who was born on 5/6/1996, and Praveen Kumar N, who was born on 25/5/1999. Therefore, even if the version in the petition that petitioner number 1 had married the respondent on 8/3/2005 is accepted, said marriage during the subsistence of marriage of the respondent with Bhagyamma is not a valid marriage, and petitioner number 1 cannot be held to be legally wedded wife of the respondent.
What is the judgment of the apex court which they are referring to?
My lord, as per the judgment of the apex court, my lord, the proof of marriage cannot be gone into in a maintenance petition. That is the gist, my lord. But however, according to the statement of the respondent number one here herself, that she is not the legally wedded wife, my lord, maintenance could not have been awarded. Further, my lord, kindly see page number
In the
37.
case of respondent, she is not a legally wedded wife.
Yes, my lord, according to her, during the subsistence of the first marriage,
She said, it's not like that.
she says that she is aware of the first marriage.
Where did she say?
She says, my lord.
Where is it recorded?
Yes, my lord, I'll just point. Kindly see page number 37, my lord.
37.
37,
Yes.
para number 17.
Hmm.
In the background of above principles, I have gone through the oral and documentary evidence adduced by the parties. PW1 in her evidence admits thus, Baswanagudi Palyada Gangu Hanumaya Embuvaru, Nanna Ganda Enuvudu
No,
Sari.
understood. That's again in English it is written.
Yes, my lord. And page number 38, my lord. Second line. However, while admitting the said aspect of PW1, has clarified that respondent was knowing well that she was married that Ganga Hanumaya, and after death of said Ganga Hanumaya, respondent has married her. Further, PW1 has admitted that ಆ ದಿವಸ ಯಾವುದೇ ಶಾಸ್ತ್ರ ಆಚರಣೆಗಳು ಮದುವೆ ಕಾಲಕ್ಕೆ ನಡೆದಿರಲಿಲ್ಲ. ಆ ದಿವಸ ಎದುರುದಾರರು ಕೇವಲ ತಾಳಿಯನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ. Therefore, during the and further, my lord, at page number 44, kindly see para number 24.
39, page number 39, above para 18.
Yes, madam.
Therefore, oral evidence adduced by the petition is not sufficient to hold that there was a valid marriage and
Yes.
respondent, which is so and so,
Yes.
has to see whether there is any other documentary evidence which supports the contention of the petitioner.
Yes.
Next 18, para 18.
Para 18. So far as oral evidence of respondent is concerned, respondent who has examined as RW1 has totally denied the allegations of the petitioners about the marriage. So far as evidence of RW2 and 3 is concerned, they say that respondent was married to one Bhagyamma and they have not seen the petitioners and they have no relationship with the respondent. RW2 having said that he has not seen the petitioners, in the cross-examination states that caste of petitioner number 1. Therefore, version of RW2 that he has not seen the petitioners proved to be false. In fact, at page number 44, para number 24, my lord, an application was also made seeking DNA test. The trial court has not undertaken the same, my lord. And at page number 50, para number 31.
He has filed the Aadhaar cards and other things.
Yes.
Where the husband, this person is shown as the husband.
This person's name is shown. But however, my lord, the subsistence of the earlier marriage is clearly admitted. Bhagyam, and further, my lord, may I just point out one document from the earlier petitions, my lord. Earlier, at first instance, my lord, she had filed a petition, similar petition, against the petitioner herein. And she had withdrawn the said petition, my lord, saying that she does not want to prosecute.
Which year is this? This petition is filed in the 2005.
Yes, my lord. She had filed a memo and withdrawn. And this is again the second petition, playing mischief upon the petitioner, my lord.
Definitely, it is not as simple as your client is putting forth there.
My lord, clearly, my lord, the statements made by her and her conduct of earlier filing a petition, withdrawing, clearly shows that. And further, my lord, the marriage.
20th, para number 20, exhibit P1 is the Aadhaar card of petitioner number 1.
Yes, para 20.
School admission register.
Exhibit P1 is the Aadhaar card of the petitioner number 1, in which the name of husband is shown as Narsimurthy. Exhibit P2 is the Aadhaar card, and Exhibit P3 is the school admission register extract of petitioner number 2, which shows that name of father of petitioner number 2 is Narsimurthy. Further,
The age of the boy.
Lord, age of the boy is shown to be 13 years, my lord. 13 years. My lord, once
So he must have been joined in the school. There must have been some records pertaining to him.
my lord, her statement that she is married to one Ganga Hanumaya falsifies the
Please,
document.
you have to be very clear.
Yes.
Two things. One is that you have no relationship with her, or she is not your legally wedded wife. As such, she is not entitled for maintenance under 125. So once it's your case that she is not a legally wedded wife, but your client had a relation with her and he is your son, it is.
My lord, I am not saying that she is not the legally wedded wife. The trial court has come to the conclusion that.
No, you say that you never knew her.
Yes, my lord, she is a stranger. According to the petitioner, she is a stranger, my lord. And she herself goes to say that she is married to one Ganga Hanumaya.
She says after that, you married her.
Yes, my lord. But my lord, the trial court having come to the conclusion that relationship is not proved, was required to direct her to go and get a declaration that she is the wife, my lord. Having not taken that exercise, having not considered the application for DNA test, my lord, fastening the liability.
Your application for that?
I'm sorry, my lord.
Where was your application for?
My lord, during the pendency of the case.
Was it recorded by the court?
Yes, my lord. Para number 24. Page number 44, my lord.
Page, para number?
Page number 44, para number 24.
Please
In the present case, petitioners had filed application to direct the respondent to undergo DNA test. This application was opposed by respondent.
The petition is agreed with orders passed by the court in criminal miscellaneous number 236 of 2021 dated 14th August 2024. Where the court had granted an amount of rupees 6,000 each to both the respondents, that is an amount of rupees 12,000. And towards legal expenses, an amount of rupees 5,000 is granted. Land counsel submits that it is a specific case of the petition hearing that the respondents are strangers to him. He has no connection with them. And in fact, he is married in the year 1995. 95, and out of the wedlock, he is blessed with 2 children. In spite of the same, in spite of an application that is filed by the petitioner herein for a DNA test, the court, without considering all these aspects, had granted maintenance, considering the submission of the counsel, which shall be stay of all further proceeding, pursuant to the order dated so and so. So the registry is directed to issue notice to the respondents. Post this matter on 19th of November.
I'm sorry for the interruption, my lord. Serial number 28 and 29, I was engaged in the other court.
Oh.
This is rejection of application order 39 rules 1 and 2.
Yes, take that 28 and 29. Pranesh Chandra for, or you inform him, we'll take it up in the after lunch.
Please, my request, my lord, tomorrow I'll inform you.
Tomorrow may not be possible. Already so many matters are posted to tomorrow. Tell him we'll take it up in the afternoon. Already the list is almost complete.
Please.
Pass over 28 and 29.
27 and 28, 29 and 20.
28 and 29.
Please.
Passed over. Yes, next.
Cell number 32, Pawan Chandra Shetty.
Advocate for appellant, my lord, there is a delay of 808
Notice
days.
to the respondents.
May I permit it to hand someone?
Petition is, no notice to respondents. Petition is permitted to serve hand summons on the counsel appearing for the respondents. Post this matter on 11th of November. A memo shall be filed to this effect, serving hand summons by November 7th, if the memo is filed on 11th.
Much
Cell number
obliged, my lord.
33, Kashinath J.
Same notice to the respondents. No representation for the petitioner. Registry is issued directed to issue notice to the respondents. Yes, next.
Cell number 34, also notice.
In this case, I am for the appellant. Here, the wife's appeal for the enhancement of the compensation.
Have you filed your objections for the delay? Huh?
No.
Yes.
Have you filed your objections for the delay petition?
Proxy counsel, my lord, proxy.
No, it is submitted. Who is appearing? Proxy counsel?
Vinod Gowda.
I am for.
Vinod.
34, 1.1.
Oh, the other Mushtaq Ahmed. Mushtaq Ahmed is directed to take notice on behalf of the respondents in RPFC 137 of 2024. And counsel submits that they'll come up with the objections, post this matter after vacation on 12th of November.
Cell number 35. Ukkanappa SB.
There is a delay, 13 days delay, madam. Notice may be.
Notice.
Date may be.
Huh?
Date may be.
Notice to the respondents. Registry is directed to issue notice to the respondent. Post this matter on 14th of November.
Cell number 36. Arun Govinda, G.V. Venkatalakshmamma.
The respondent sought time on the last occasion, to place a list of medical and educational expenses of the minor child.
I appear for the respondent, my lords. My lords, may I request for a passover in this matter?
Also. Next.
Bill number 37. Dixit, you.
Appear for the petitioner in this matter. The petitioner will be allowed to withdraw the amount which was deposited, since the petition is already allowed in favor of the petitioner.
What is it? Disposed of. Why they are not mentioning here? The disposed matter, that's what we said on the last occasion. The order dated had disposed of, no IA number constant submission of the confirmation. Order dated is recalled and the writ petition is restored to file.
Rajesh Shetty.
Respondent. Is a disposed of matter. Earlier, there was an order for release of the amount to the respondent on 4/3/2024. Thereafter, I have filed an application on 11/3 for release of the amount. Meantime, the final order was passed and the matter was remanded. After remand, there is again an order directing him to pay more than 4 lakhs. Now the amount has to be released to the mother. He has deposited earlier when the interim order was granted. Now there
Why do you want to withdraw that amount that the court is not able to understand?
My only submission is, I want to withdraw it because I want to give it in the trial court.
We will say, we'll say that let it be transferred to the trial court, and from the trial court,
It may be released because I already
No.
applied for the amount in the.
Because
let's not complicate things. Ultimately, you are going to have it. Please wait. We'll tell the whatever amount that is pending, that is lying before this court, that will be sent to the trial court. And the trial court shall permit the respondent to withdraw the amount. Yes, please come. IA number in a disposed of matter. This IA number. When is this order? Oh, this is the dismissal order. 27th March 2024 is the order. This matter, the court has remanded the matter.
Yes.
After remand also, there is an order directing him to pay more than 4 lakhs.
No.
That order I
What is
produced.
this 5/3/2024 order?
5/3 it was dismissed, then it was.
IA was dismissed.
The main matter itself was dismissed since he didn't appear. Then it was restored and heard on merits and matter was remanded back.
Why this order should have been back? Why it is 5/3/27/2024 order is no. It is disposed on 27th March. This should come here. Oh, it should be after this. So that's what I'm not able to understand what is happening. No, earlier, this court had disposed of the matter by order dated 27th March 2024. By setting aside the order dated 4/11/2022 and remanded the matter back to the trial court. It is submitted that after the remand, the court had passed an order.
I produced that order also.
Court passed an order directing the husband to
Not
pay.
husband, son.
Son, for directing the son to pay an amount of rupees.
Nowhere the amount is mentioned, my lord.
5,000.
No.
Mentioned.
No. Nowhere the order
Can't
says.
read clause number 2, please read it.
5,000.
The court had granted 5,000 maintenance per month from the date of petition. And the son is directed to deposit the arrears of maintenance within 3 months and continue to pay the maintenance till her lifetime. And he was also directed to deposit the costs along with arrears of maintenance.
That is the trial court
Cost
order, my
of
lord.
an amount of rupees 25,000 is also awarded. This order is dated 15th of July 2024. During the pendency of this petition, the petitioner, the son had deposited an amount of rupees
2 lakh rupees.
2 lakh rupees before this court. Now, he files an application to permit him to withdraw 2 lakhs as which is deposited by him by DD number 213403 as the matter as itself is disposed of by this court. Then counsel for the respondent submits that when the court had passed an order and the court had directed him to pay the costs as well as the maintenance at 5,000 from the date of petition and continue to pay him till the lifetime. Now, he may be permitted to withdraw the said amount. Considering the same, IA number 3 of 2024 is disposed of, directing the registry to transfer the amount to the trial court. And the trial court and the petitioner, the respondent mother is permitted to withdraw the said amount from the before the trial court. Accordingly, application is dismissed. Next.
Cell number 38. Hemalata Mahishi for petitioner. Jagdish Gundappa.
I'd like to appear for the respondent.
What is happening?
Custody orders has been challenged, Mr. Lodge.
In the High Court, the client shall not make any mention like this. Will pass over.
Very well.
Pass over.
Cell number 39.
Chips can have it tomorrow afternoon. I have some. Afternoon, I have some.
Because now today afternoon there is less work, but tomorrow we don't know. There's a lot of matters. That's why you come at your convenience. You complete your work and come. Inform the council when you are coming. Yes.
Cell number 39. Correspondent.
My lord.
We've recently
come on record for this said case. We have
Uh-huh.
objection. We've recently come on this said case. We filed a wakalat. We need this short accommodation to file our objections to this.
At the request of, what is your name?
Account.
No, who is the council, whom you are representing?
Respondent,
Huh?
Rajesh.
Sonia Rajesh. It is submitted by the council that recently they have filed wakalat and they want to file objections to the petition. At their request, post this matter on 5th of November.
Final
Yes.
hearing, cell number 40.
Much obliged.
Keshav Reddy,
This case, I am for the appellant.
HR.
This case, IA 2 and 3 is pending. IA 3 is the impleading application. In the last occasion, he said that the land is handed over to the National Highway Authority of India. Hence, I made a party to this proceedings. He is a necessary party. And
Let it be, if something has been done, that you can take care before the trial court. That you can take care before the trial
the
court.
trial court judgment is passed. Judgment passed.
Is challenging the LAC for
That-
enhancement.
Oh, it is a land acquisition.
Land acquisition,
Land acquisition
Impression
matter.
that it's a secret.
National Highway matters.
National Highway Authority of India.
Uh,
National Highway Authority of India is the beneficiary.
Where is IA?
A 1 of 24. Permission to.
I am for the 1 and 2.
IA number?
IA number 3,
Impleading.
Impleading applicant.
impleading application.
I 1 of
IA 1
Oh,
already allowed.
25.
IA number 1 is already here. Is
No, already,
IA 1 is to implead.
Yes.
It is allowed.
Allow agila. Impleading application is not allowed.
Impleading application is not yet allowed.
That's what it is. Impleading
pending.
application is IA number 1.
IA number 3.
What I can see from it.
Wait. You have checked it. My impleading application recently as filed.
Recent.
Allow the, implead the proposed third
Yes.
respondent as a
Respondent,
party.
Yes.
Yes.
That's IA number 1 of 24.
Then. 1 of 24.
IA number 1 of 24 is a continuation of delay.
No. That is a already.
23, that you filed it in 2019.
Don't confusion. I'll let.
IA number 1 of 20, registry is directed to issue notice to the respondents.
I need some time to file my objections of I need some time to file my objection, respond 1 and 2.
Filed by you himself to include yourself in this.
Already is made a party. I am for the respondent 1 and 2.
Yes, 3.
3 is now is filing an application for implementing.
Issue notice.
He is undertaking that.
No. I can't. I'm not the. Please, kindly issue a notice.
IA number 1 of 24, registry is directed to issue notice for the party.
Date may be given.
Pose this matter on 5th of November.
Please.
Cell number 41. Sir, MB. Appellant.
Seeking for an adjournment, my lord.
Shanti
Senior.
Bhushan.
Give that, let's see what is. Give the docket.
My lords, kindly grant a short accommodation, my lords.
At the request of non-counsel, the appellants post this matter on 23/9. At the request of non-counsel, the appellant lists this matter after 2 weeks. There is no representation on behalf of the appellant. List after 2 weeks, list after 1 week, no representation. The matter has underwent adjournments every time the matter is listed. The appellant is seeking time. Appellant is not interested to pursue this matter. Poses appears that he is not interested. Poses matter on
My lords,
December
kindly
20th,
pause.
December 19th. Yes, next.
Cell number 42. Shivraj Party.
In this case, appearing for petitioner, your lordship.
For appellant Ajay.
Your lordship, the respondent husband obtained a decree of divorce by placing an ex parte, your lordship. Ex parte order has been obtained without service of notice. Your lordship, kindly
How is
wish.
it listed for this court? No, when an appeal is dismissed or an ex parte order is passed, then if it is a family matter, why will
No.
no, he says suit for he says divorce, you are saying.
Yes, your lordship. Then I filed a miscellaneous petition, your lordship, Part 9, Rule 13.
Oh.
It was dismissed. Against that order, I prepared this MF, your lordship.
Yes.
Your lordship, kindly see the order sheet, your lordship, page number 35.
When an ex parte order is passed?
The ex parte order is passed on
Ten 12/2021.
Yes, ma'am.
When did you file an application to set aside that order?
The interim we filed, your lordship.
Huh?
We filed in before the same court, and the delay was condoned. The evidence was led. What happens in this case, your lordship? Notice was served on her son, your lordship, the petitioner son. Both petitioner and respondent, your lordship, even after taking divorce, your lordship, both are sitting in the same house.
Please inform the other side, we'll pass orders in the afternoon.
Yes, your lordship.
Cell number 43. NB Nijalingappa for petitioner. S. Nagaraj.
No representation on behalf of both the parties. Poses matter on 17th of December.
List number 2.
Yes.
List number 2. Cell number 1.
My lords, I appear for the petitioner in the connected matter, my lords. My lords, we have deposited, my lord, the arrears of 1 lakh rupees before this honorable court, my lords. Today morning, my lords, it was deposited.
Let him withdraw it.
Please, my lords.
It is submitted that as per the order passed for this court, an amount of rupees 1 lakh.
1 lakh, my lords.
Only 1 lakh.
Arrears was 1 lakh, my lords, I have
1
deposited.
lakh was 1 lakh is deposited by the petitioner before the registry. By way of DD, the respondent is at liberty to withdraw the same. Yes.
Please.
Great.
My lords, one more submission. My lords, my lords, this matter was, my lords, my lords, may I make one submission, my lords? This matter, my lords, pertains to only interim maintenance. My lords, assets and liabilities by both the parties are not filed, my lords, even before the trial court. My lords, I will, my lords, meanwhile, continue to pay, my lords, whatever is directed by this honorable court. The matter be remitted back to the trial court, my lords, for fresh consideration.
Do that.
Please.
But the problem is, why both of you are not filed? Why should the court should do
My
the
lords,
exercise
at
again?
the relevant point in time, my lords, it was not mandatorily asked.
Neha, the judgment is not there.
No, my lord. It was not during the regime.
That is why, my lords.
Where is the order?
My lords, order is at, my lords, page number
The order is passed in I number 3.
10, my lords, at
C
annexure
number
A.
241 of 2019, dated 4th January 2020, whereby the family court had granted interim maintenance of an amount of rupees
10,000 per month.
10,000 per month to the wife and litigation expenses of an amount of rupees 15,000. Both the husband and wife had come, they have come before this court. The petition filed by the husband is WP number 4082 of 2020, and the petition filed by the wife is WP number 4440 of 2020. As per the orders passed by this court, the husband had deposited an amount of rupees 1 lakh by way of DD before the registry, and this court had permitted the wife to withdraw the same.
And earlier I had deposited 1,90,000, my lords, in total.
Earlier it is 1,90,000.
My lords, by virtue of order dated, my lords.
By virtue of order dated?
My lords, 20th February 2020, my lords.
20th?
February 2020.
20th February 2020, how much is deposited?
My lords, 5,000 rupees was directed to deposit on every month, my lords, and 15,000 towards litigation expenses.
He was directed to deposit 5,000 per month and 15,000 as
litigation expenses for once.
He has deposited the amount of 15,000 and also.
And 5,000 till today, my lords, I have continued deposit.
At the rate of 5,000. Earlier, 1,90,000 was deposited.
Earlier, 1,90,000 was deposited, and now 1 lakh is deposited. That you have already withdrawn.
No. It is all with the registry. I'll withdraw it now.
1,90,000, and now another 1 lakh is deposited. This court had already permitted in that earlier order, write that also in the docket order. The total 2,90,000 is permitted to withdraw. This court has passed an order permitting him to withdraw the amount. Both the counsel submits that as that point of time, the judgment of Rajneesh was not there, and as it was not mandated, they have not filed a statement of assets and liabilities. As it's an interim or interlocutory order, interim maintenance is granted. If the matter is remanded, they'll be able to file their statement of assets and liabilities. And the court would be able to arrive at a just conclusion. What is the maintenance the wife is entitled to? Land counsel appearing for the petitioner submits that. Petitioner husband submits that. The husband will continue to pay 5,000 till the application is decided by the trial court. Considering the same, this court is passing the following order. The order in I number so-and-so by so-and-so, dated so-and-so is set aside, and the matter is remanded back to the trial court for fresh consideration. Both the parties shall file their respective statements of assets and liabilities within 4 weeks from the date of receipt of the copy of the order, and the trial court shall decide the interim application for maintenance within 3 months from there on. Till such time, the husband shall continue to pay 5,000 to the wife.
Wife is permitted to withdraw the deposit.
Next, the amount that is already deposited before this court, that is an amount of rupees 2,90,000. The wife is at liberty to withdraw the same.
Husband shall deposit before the trial court or, my lords, directly to the wife. Husband, my lords, 5,000 to be deposited to the account trial court before the trial court, my lords.
Why
Or
you want Let him, you can also, he shall continue to pay deposit 5,000 before the trial court.
Please. my lords.
Instead, let him pay directly.
This time you can withdraw from the registry itself, 1,90,000.
All.
80,000.
Trial court amount.
No, trial court, before the trial court, he'll be continuing to deposit every month. You can withdraw.
Because Lord, there is an there is a petition filed for transfer. Now the wife is residing in Bangalore. The proceedings before trial court is stayed in that transfer application also.
So what is the difficulty in transferring the amount? You will have a record for that bank
Directly
transfer.
let them transfer.
No, if they give the account details.
The respondent wife shall furnish the bank details to the husband and he shall continue to
Please.
transfer the amount by every month by 5th
Please.
of every month.
Please, I shall do. Grateful.
Yes,
ma'am.
next.
Number 2, Dayalu KN for petitioner Purushottam G.
Petitioner. Husband's petition.
Hmm.
This court had granted.
Where is the counsel? Passover?
Maybe call someone. Maybe call some other time.
Some other day. Counsel to the respondent.
After
Counsel for the petition is present. No representation for the respondent. Pose this matter on 29th October. Interim order is there. Interim order, if you look at it, if the interim order is there, extend till the next date.
Interim order is there.
Yes. Any Passover matters?
So matters ready.
Matter,
Yes.
Number 1, sir.
please.
Yep, here.
No, this one, serial number.
Hmm.
My lord, the appellant is challenging, my lord, the order passed by the trial court on IA number 28.
I number?
IA number 28,
Item number 28 is your vacate petition.
please. IA,
And injunction is granted in IA number?
IA number 28.
Uh,
Injunction granted in IA number 2.
2. Yours is vacate is 28.
Please. No, ma'am, not, this is not the vacating. Is another application filed by the plaintiffs seeking an injunction restraining the defendants from changing the nature of property or from digging trenches.
Initially, it was not to create third party rights.
Not to create.
That is IA number?
IA number 2.
Third. Basically, because an order is already passed, not to create third party rights, the court has granted injunction in IA number 28.
Please, my lord. Now, my lord, what he is trying to say is indirectly he wants to restrain me from enjoying my property.
No, please come to the averment with regard to the possession wherever it is made in the
My
plain
lord,
or.
in IA, he says, my lord, with regard to, my lord, para number 7.
Page number?
Page number 47, my lord. My lord,
47.
47.
Huh.
My lord, last 5 lines.
Yes.
That there is a immense threat from the defendants to the peaceful possession and enjoyment of the plaintiffs as the on the
That's para number?
para number 7, my lord. Page 47.
Some numbers are there, two numbers are there.
Sorry. My lord, IA number, this is
Para number 7 I'm
para
looking
number
at.
7. Last 5 lines, my lord. Commences with the word that there is an immense threat from the defendants to the peaceful possession and enjoyment of the plaintiffs on the suit property. The police declined to give protection to my possession to control. The
Para number 7 is not that. Para number starts with the defendant number 10 is here with denying the averments. That number, there are 2 numbers on that paper, 50, 51, 45, 44.
My lord, there is one paragraph number 7 that is, my lord, IA. My lord, IA filed under order 39 rule 1 and
That is at, as per the court, it is 47 page number.
Page number 40. My lord, bottom, my lord, in that paragraph number 7.
The plaintiff being the law abiding citizen
Such
is not a position to control the onslaught.
that there is an immense threat from the defendant. It starts with the word.
That there is
last
an
5 lines.
immense threat from the defendant to the peaceful.
To the peaceful possession and enjoyment
This
of
is
the.
what it is. They say that he is in possession of the property.
He says, my lord, by virtue of seeking, and what now he is saying is, now he is trying to make out a case that
I am not in possession of the
No, no,
property.
not about this. I'm saying while the court deciding this I number 2
Please, my lord.
earlier, in that, what is the finding of the court with regard to
Finding of the
possession?
court, my lord. Your lordship may
That's the
kindly,
important aspect.
now your lordship may kindly, I have
You passed on.
passed on.
Oh.
My lord, page number 6 in the 16 in that order.
Page number 16.
16, 616, my lord. Third line. The plaintiffs are not seeking the interim relief of injunction, restraining the defendants number 8 to 10 from the interfering with their possession. But they are claiming only to restrain the defendant 8 to 10 from alienating the suit property. Now, alienation is made by the defendant number 10 in favor of defendant number 11, and in turn, defendant number 11 in favor of defendant number 12. If the chain of alienation continues in pendency of the suit, it is plaintiffs who will be put to inconvenience in search of subsequent purchasers, and he has to run pillar.
Please come to the plate.
Please. My lord, plaint is at page number 63, my lord. That is mainly relies upon, my lord, the judgment passed in OS 85/1969.
So according to them, the plaintiffs and defendants are common from some grandfather is.
No, my lord, what they are saying is they have purchased the property year 1965, 62, and thereafter, my lord, a suit came to be filed for a permanent injunction in OS number 85/1969. That suit
No,
came to be.
according to him, the defendants are interfering of the fact that the common ancestor is one Subbaraya Gowda, he has 2 wives and all.
My lord, a common ancestor, my lord, is concerned. My lord, the defendants have purchased, my lord, the property. There are several transactions which have taken place.
This relation is referring to which defendants?
That is referring to the, my lord, relationship, my lord.
With some of the defendants they might be having, there are subsequent purchases.
Subsequent, there are several.
What
my
it
lord,
says
now the
is
present-
Subbaraya Gowda
Yes,
had
my lord.
2 wives. This plaintiff
That is,
is
my lord, in
from.
between there was a transaction. Originally, my lord, Hanumayya, son of Hanumantappa. That was from there, he purchased the property, and subsequently there is an alienation to Patel Sanjeevappa. Thereafter, Nagamallaya purchased, and thereafter it was again.
Come to para number 2, he says, second wife name Akkamma, who is no more and has got only one same by name Bhupala Gowda, who is also
My
no
lord,
more.
they are claiming through Bhupal Gowda.
Yes, they're claiming.
Plaintiffs are claiming through Bhupal Gowda.
Bhupala Gowda.
Bhupal Gowda had filed a suit
Uh,
for permanent injunction against his vendor.
Who is his vendor?
His vendor is, my lord, Sanjeevaya, Sanjeevam, I thought it appears. Lord, I have passed on the documents along with the memo, my lord. Munishamappa. Subraya Gowda is the father of Bhupal Gowda. Subraya Gowda had filed a suit, my lord, page number 77, my lord. I have, in the compilation I have filed the judgment of passed in OS.
During his lifetime, that Bhupal Gowda has filed the suit. That's OS number 885 of 1969.
Please.
Uh,
Again, it's Munishamappa, Bairana.
His brother Bairana.
Bairana. By that time, before filing the suit, there was already alienation made. Your lordship may kindly.
By whom?
My lord, by the identity of
The vendors or the grandfather?
My lord, the identity of the property is entirely disputed. the Tahsildar passes an order in the year 2005, 5 and 6. An order came to be passed. An
Yes.
application was made to the Tahsildar for requesting them, the Tahsildar to mitigate the revenue entries. Sorry.
Yes.
Tahsildar passes an order directing the
I
parties
think
to.
I'll just complete reading the plain so that the facts would be clear. We can go further. Revenue records are in whose name?
My lord, revenue records are in the name of the defendant number 10.
Defendant
Now
number?
your lordship may kindly come to, in compilation, I have filed, my lord, the order passed by the Tahsildar. My lord, there are two other suits filed by the, my lord, one filed by my vendor for declaration, which is decreed in respect of 3 acres 13 gunta.
What is the suit?
Suit OS number 65/2006.
60?
65/2006.
65/2006.
2006.
By your vendor, who is, which
V.
defendant is
Krishnappa.
he?
V. Krishnappa against Chennamma.
Who is Chinnamma?
Chennamma is, my lord, the wife of Gopal Gowda.
That was decreed when?
That was decreed on 29/9/2007.
29/9.
2007. And one more suit for partition was filed by the very same parties in OS number 347/2009, which is renumbered as 215/2015. 214/2015. My lord, this is during the pendency, my lord, an application was filed for rejection of the plaint in the partition suit on the ground of limitation. Subsequently issued.
In that partition deed, I remember now, you say that they sought for the cancellation of the sale deeds right from 1964.
My lord, there was, the claim was based on the sale deeds. There was a limitation, my lord, an application for rejection was filed on the ground of limitation. The trial court framed preliminary issue with regard to limitation.
And allowed it.
Allowed the application and answered affirmatively, holding that, my lord, the plaint is liable to be rejected and.
Then again, after that, they filed a declaration suit. The present suit.
This was filed in 2010. What has happened, my lord? The earlier partition suit was filed in 2009. This suit was filed in the year 2010. They do not disclose in this suit with regard to filing of the partition suit. In this suit also, claim is based on, my lord, the decree passed in 1969. They are challenging the sale deeds right from the year 1965.
No, that is one aspect. No, when they are seeking any, they're saying that they are in possession of the property. What all the documents they have shown right from there to now?
Now their claim is based on the decree passed in 1960.
Not the decree, other than the decree.
Other than that, they do not have any other documents, my lord, except the earlier sale deed. Earlier sale deed.
And you have the revenue entries.
Revenue entries in our mind. And now, my lord,
Well,
having
it's very
suffered.
strange that you have not, with all these facts and circumstances, you have not questioned that order.
My lord, what happened, my lord? I was impleaded subsequently, defendant number 10 was impleaded. Originally, my lord, I have purchased, my lord, portion of the property. And during pendency, the remaining portion of 3 acres I have purchased. Now I am owner of 7 acres of land in survey number 11.
7 acres. First, when was the purchase?
My lord, in year 2021.
That is half of the land. How much?
Half of the land, 3 acres.
Now, how much you purchased?
Now, subsequently 4 acres. Totally, I have purchased 7 acres. 21, my lord. 2021.
No, you said 3 acres initially.
9, my lord, both the properties were purchased on 9/7/2021.
So you are a pending delayed purchaser.
Please, pendant deposit. And my vendor, V. Krishnappa, had filed a suit for declaration in respect of 3 acres 13 gunta.
What about the remaining extent?
Remaining extent, my lord, V. Krishnappa had sold 4 acres and retained 3 acres 13 guntas. He filed declaration only in respect of 3 acres 13 guntas. 4 acres were sold to one T. Ramegowda, and subsequently it was purchased by the defendant number Mahadeva Gowda, and from whom the appellant has purchased on 9/7/2021. And in the plaint, your lordship may kindly come to the prayer column.
They don't even say anywhere about their position.
They don't say. My lord, paragraph number 12, your lordship may kindly. So far as the possession is concerned, they refer paragraph number 12. The plaintiff submit that on the strength of the alleged sale deeds, the defendant number 2 to 10 are making attempts to interfere with the peaceful possession and also denying the right, title and interest and possession of the plaintiffs over the suit scheduled property. And the defendants 8 to 10 once again came near the suit scheduled property and 10/5/2010 and made attempts to dispose of the plaintiffs from the suit scheduled property. The same was resisted by the plaintiffs and the plaintiffs have approached the jurisdictional police for protection. But the police have failed to,
They don't, do they seek recovery of position?
they do not seek any recovery of possession. And also, my lord, surprisingly, in the plain paragraph number 12, they say that, my lord, the defendants are interfering with the possession. He do not make any application to restrain the defendants from interfering with the possession. He only seeks higher number 2, not to alienate. If at all he was in possession, he would have made an application. He was not at all in possession of the property. And moreover, my lord, my vendor's vendor Krishnappa, after purchasing, my lord, he had constructed a small shed, my lord, farmhouse in the portion of the property. And also, my lord, his ancestors were buried there in the scheduled property, in portion of the scheduled property. Because of that reason, my lord, he has retained 13 guntas for himself and sold the remaining extent of 7 acres in.
No, the difficulty is, he has filed a suit for declaration and injunction. And to say that, declare that the sale deeds are not binding on them.
Please.
He has not sought for any recovery of position. It is his assertion that he has been in possession of the property. He has never filed a petition for IA for injunction. So court had no opportunity to decide who is in possession of the property.
Please.
When he has asked for a relief of not to alienate, court gives a finding with regard to a prima facie case and other things and grants an order.
Prima facie case recording during pendency, there were alienations. I'm
So
also
the court grants an order.
only on that ground.
No, they say that they are in possession of the property
My lord,
and they have been interfering and as
Lord,
such.
when the suit was filed year 2010, in the plaint, there was such an allegation made in para 12. If at all he was in possession of the property, he would have made an application long back. My lord, prima facie, my lord, granting.
Why don't you file an application for restraining him from, because you are in possession of the property and in fact, under
I'm
the guise
carrying
of
out
these.
agricultural activities and my lords, my vendors, my lord, ancestors were have been.
Because all those have to be on record.
My
Now,
lord,
this is a
the
kind
trial
of.
court does not even refer to what I have stated in my objections. I refer to OS.
We'll do one thing, we'll set aside this order.
Please.
We'll and whatever appropriate application you also want to make.
Please.
Let the court consider it.
Let the truth.
I'll record your submission. Agreed with the orders passed in. I number 28, in OS number 89 of 2010 dated 30th March 2024. The defendant number?
My lord, defendant number 10.
Defendant number 10, who is a subsequent purchaser, is before this court. It is the case of the respondent herein. Who is the defendant, or who are the defendants as per the cost title? The respondents 1 to 4. Or the plaintiffs in the suit had filed a suit seeking.
My lord, 1 to 5 plaintiff.
1 to 5 have filed the suit. Page number, the reliefs that are sought.
My lord, reliefs that are sought in page number. My lord. My lord, plaintiff page number 63, reliefs that are sought in page number 73, my lord.
Sought, the suit is filed seeking the relief of declaration that the plaintiffs are the absolute owners and lawful possession and enjoyment of the property. by virtue of the judgment and decree passed in OS number 85, 1969, dated 25/11/1978, in favor of the father of the plaintiff, consequently declared the sale deeds executed right from 14/7/1965, and also the subsequent sale deeds which are executed by the defendants. It is a specific case, it's a specific case of the plaintiff that the common ancestors for plaintiff and the first defendant was one late Subbaraya Gowda. The Subbaraya Gowda was married with two wives, first wife by name Sanjeevamma, who is no more and died issueless. Second wife by name Akkamma, who is no more and who has got only one son by name, late Gopal Gowda, who is none other than the father of the plaintiff. It is a case that the grandfather Subbaraya Gowda had acquired the scheduled property by virtue of the registered sale deed dated 14/11/1962, and ever since his imposition enjoyment of the land. It is a case that when there was interference, he had filed OS number 85 of 1969 on the file of the Munsif at Dodbalapura against Munisha Mappa and his brother Bhairana, who are the sons of late Erappa and others, that is the vendors of Munisha Mappa and Bhairana. And the said suit came to be decreed on 26/11/1978. It is the case of the plaintiff that when there was an interference from the defendants, then he came to know that defendant numbers 7 to 10 have gotten a sale deed. Thereafter, the plaintiff has approached the sub-registrar's office, and on verification, the plaintiff came to know that the second defendant executed the sale deed in the year 65/66 by document number 1194 of 65/66 in favor of the third defendant. Thereafter, the third defendant has executed a sale deed in favor of fourth defendant on 30/10/1968. Thereafter, the fourth defendant sold the same in favor of the fifth defendant on 22/1/1980. And during the pendency of the suit, the present suit is filed in the year 2010. During the pendency of the suit on 30/11/2017, the ninth defendant had sold the land. And on 3/5/2018, the 10th defendant sold the land.
Sold again, he purchased.
So again sold to 10th defendant. The court initially had filed I number 2, seeking an injunction restraining the defendants from further creating third-party rights. The court, by order dated 8th July 2022, had passed an order restraining the defendants from further alienating the property. While by order dated 8th July 2022, while granting such an order, the court has observed that the present dispute in respect of the property is the title dispute with regard to the property. The plaintiffs are claiming the title of the suit scheduled property on the basis of the registered sale deed dated 14/11/1962. The survey number 35/2, a new survey number 35/2A and 35/2B. The plaintiffs are also claiming that the rights of the grandfather, Subbaraya, and his position of the property is protected with a decree of permanent injunction passed by the Municipal Court in OS number 85 of 1969. And the defendants are denying the title of the plaintiff. And the court observed that The plaintiff has made out a prima facie case. And the plaintiffs are not seeking the interim relief of injunction, restraining the defendants 8 to 10 from interfering with their position, but they are claiming only to restrain the defendant number 8 to 10 from alienating the property. If the alienation is made by defendant number 10 in favor of what is this? Alienation is made by defendant number 10 in favor of defendant.
That is alienation made and subsequently purchased on 9/7/2021.
You are defendant number 10.
10. I'm in possession. I am the owner of 7 acres.
You have sold already in favor of defendant 11 and 12.
11 again purchased it. 9/7/2021.
Oh, I didn't understand this. No, you sold away the property.
Sold, again purchased on 9/7/2021.
The defendant number 10 had sold the property in favor of 11 and 12 and again purchased
From
it.
them, I have purchased again.
Purchased again.
Again, on 9/7.
Purchased again by defendant number 10. The court has observed that the balance of, if these transactions goes on, there will be a multiplicity of proceedings. And in fact, the balance of convenience and irreparable loss lies in favor of the plaintiff. In view of the same, the court had granted injunction restraining the defendants from alienating the property, either by creating any kind of charge like sale, mortgage, and third-party interest or the property till further orders. Thereafter, IA number 28 is filed by the plaintiff, wherein he has sought, where is that IA?
My lord, IA is on page number 42.
Page number 42.
Sorry, page number 40.
Now, by way of this IA number 28, the plaintiff had sought an ex parte temporary injunction restraining defendant number 10 from changing the structure of the scheduled property, either by way of digging trenches or by way of putting up any construction in the property in any manner pending disposal of the suit. In support of that, an IA is an affidavit is filed. In the affidavit, it is stated that the plaintiffs, being the law-abiding citizens, are not in a position to control the onslaught, mighty illegal interference of the defendant number 10, and is not in a position to withstand and control the illegal acts of the defendant number 10. That there is immense threat from the defendants to the peaceful possession and enjoyment of the plaintiff on the suit property, and the police have declined to give protection to his possession to control defendant number 2 on the ground the dispute is civil in nature and directed him to approach the civil court. The trial court, by order impugned, had allowed the application. While allowing the application, the court has observed that on 8/7/2022, the court has passed an order in IA number 2, whereby an injunction is granted restraining the defendants from alienating the property, and the same has attained finality and operating against the defendants number 8 to 10. The plaintiff has filed a memo along with the photographs and CD and police NCR on 5/1/2024. The photographs clearly discloses that the defendant number 10 is digging the trenches by using the JCP. Title of the plaintiff, which assistance of the suit property is a dispute in the suit. If the defendant number 10 is not injuncted, then defendant number 10 will continue with digging trenches and making construction over disputed property. The matter involved in IA number 28 is regarding allegations of changing nature of the suit property. If the nature of the suit scheduled property is changed, it will be put to irreparable loss and inconvenience, and accordingly, the order is granted by the injunction is granted by the trial court. Learned counsel appearing for the appellant defendant number 10 submits that the originally the suit is the suit is filed in the year 2010. Before the suit is filed in the year 2009, they filed a suit for partition and also sought for cancellation of the earlier said deeds. Then on the ground of litigation, when the defendants therein, who is a vendor of the plaintiff, had taken a vendor of the defendant had taken an objection, the court had upheld the said objection, and the court and the suit itself is dismissed. It is the case of it is submitted that the said fact was not disclosed in the suit, which is filed subsequent to that. It is submitted that the vendor of the defendant had filed OS number 65 of 2006 on the file of
My lord, a civil judge at Dodbalap.
civil judge at Dodbalapur seeking declaration against the
Chennamma.
against
Chennamma, wife of
Chennamma, who is the wife of
Bhupalagowda.
Bhupalagowda, and the said suit came to be decreed on 29/9/2007, and the said judgment and decree had attained finality. All these aspects were not placed before the court, and the vendors the first sale deed is of the year
65.
65, and thereafter several transactions have taken place. When the earlier order is passed, as the defendant had no intention to alienate the property, he had not filed any appeal against that. Now, because that order has attained finality, without giving any findings, the trial court had allowed this application, whereby the plaintiff is trying to project that he is in possession of the property and defendant is encroaching defendant is altering the nature of the suit scheduled property and is not able to protect his possession. Land counsel further submits that the trial court all the revenue records are in the name of the defendants and their vendors right from the beginning, and not except the suit that is decreed in the year
1979.
1979.
79.
There is no, not 79.
Nineteen 25/11/1978.
78. 29.
11 25/11/1978.
25/11/1978, except that there is no other evidence to show that he is in possession of the property. He submits that when the defendant is not in possession of the property right from 1967. Question of granting.
And there is also dispute with regard to identity of the property.
And dispute with regard to identity of the property, the court ought not to have granted such a relief. In this case, one Mr. N. Krishna and Shankara have filed the caveat in this case. This matter has come up before the court on on 38/2024, as it is submitted that it is submitted before the court that the caveat is filed on behalf of respondent number 2, and the copy of the appeal memo is also served on the counsel for the respondent. Then, on that day, the matter was adjourned, and later the matter was listed on 4/9/2024. This court had directed the petitioner to appellant to comply with the office objections. Thereafter, on 12/9/2024, memo is filed seeking dispensation of notice to respondents 1 to 9, 11 and 12, and another memo is filed seeking dispensation of notice to respondent numbers 10, 13 to 18. As the appellant is not claiming any relief against the said respondents, and the risk of the appellant, the notice to those respondents is dispensed with. When the matter came up for admission on 29/2022, 2024. It is submitted by the counsel for the appellant that they have already served the papers on the caveator. There is no representation for the caveator on that day, and the court had heard the counsel for the appellant in part and posed the matter on 21/9/2024 on the top of the list. When the matter came up on 21/9/2024 also, there was no representation on behalf of the respondent in the forenoon as well as the afternoon. This court, again, the list directed the matter to be listed on the top of the list today. Today also, there is no representation on behalf of the respondent plaintiff. Hence, this court is proceeding with the matter basing on the merits, basing on the material available on record. The learned counsel appearing for his contentions are recorded. Having heard the learned counsel for the appellant, peruse the material on record. The plaintiff is claiming title to the property basing on a sale deed that is executed, basing on a sale deed in favor of his grandfather. It is also not in dispute that there are several litigations pending between the plaintiff and the defendant. One suit that is filed with the plaintiff's grandfather was decreed, and the other suit that is filed by the vendors of the defendant, who is the appellant before this court, is also a suit for declaration. Declaration is decreed, and the suit that is filed for partition by the plaintiffs, and where they also sought for cancellation of the sale deeds. The said suit was rejected as the same is barred by limitation, as the relief that is sought is barred by limitation. And several transactions have taken place right from 1966-67, when the defendants have purchased a property until it was sold to defendant number 10, who is appellant here, and had sold it to 11 and 12 and again purchased it. And there are a series of transactions from 1967-62 till now. Earlier, when the court had given a finding of prima facie case and balance of convenience in favor of the plaintiff, and an injunction is granted by way of I number 2, restraining the defendant from alienating the property, the defendants ought to have questioned the same. The submission of the learned counsel of the appellant is, as they are not inclined to sell the property, they are not, they have no intention to sell the property, they have not questioned the same. Now, when this application is filed, where the defendant is stating that he is in possession, the plaintiff is saying that he is in possession of the property, and the defendant is changing the nature of the suit schedule property forcibly, the court, in the light of the earlier order passed, allows this application also, that is I number 28, restraining the defendant from changing the nature of the suit schedule property. The court, in this case, ought to have given a finding with regard to who is in possession of the property and what is, and a specific finding ought to be given by the court by passing this order. Just because the defendants also ought to have questioned it. Now, at this juncture, as there is already a finding by the trial court with regard to the prima facie case and balance of inconvenience in favor of the plaintiff, and in this application, this court cannot, in this appeal, this court cannot give any finding on that, and the defendant was in possession of the property, and the plaintiff had come up with such an application, he could have as well filed an application for injunction, which is not done in that view of the matter. And even the order impugned also, the no reasons are given by the court, except stating that the defendant had not questioned the earlier order in that view, and full stop. If this order is granted, it amounts to saying that the plaintiff is in possession of the property. In that view of the matter, the trial court ought to have decided all these issues. Accordingly, this court is passing the following order. The order dated so-and-so, so-and-so, by so-and-so, dated so and so, is set aside. And the trial court shall consider the same afresh by giving reasonable opportunity to both the parties to put forth their case. Second, if uh, if the petitioner wants to file an application seeking injunction, the appellant wants to file an application for injunction, the appellant is at liberty to file the same accordingly. The appeal is disposed of.
With my lord's kind leave,
No, by adjournments now.
my lord, the matter was for settlement and in-chamber proceedings, my lords. I'm for the respondent in the writ petition number 7182 of 23 today. So, my lord, the respondent's uncle is passed away today morning. So, the matter may be adjourned to 30.
Yes, 2 o'clock or 5 o'clock?
5 o'clock, my lords. Seal number 45.
It is submitted by the. It is submitted with the learned counsel for the respondent.
Yes, my lords.
Respondent that the respondent's father has passed away in the morning. Post this matter after
30th of September, my lords.
after vacation on 30th of October. So 30th, you want it on September?
Yes, my lords.
It's 30th of September.
On submission.
Much obliged.
Yes.
Serial number 23, my lord. They have moved adjournment without our knowledge and information. They have taken adjournment. It is set down for admissions there is no interim order. This court, on the last date of hearing, this.
23, on what reason it is adjourned? Huh? Counsel is unwell.
Yes, ma'am. In the morning itself, they have moved on adjournment. We are waiting.
No, they said that the counsel is unwell. What to do?
Please, ma'am, there is no interim order as such. The interim order may be.
Because they asked adjournment, interim order has to be given now.
Because what happened, there is an urgency, they have taken time.
No, so tomorrow, you are not,
Please.
when you are not well, what to do?
Tomorrow.
If on some occasion, when you are not well, if an adjournment, when a request is made, the court has to consider or not.
They're pressing the execution there.
When is it listed? When is it directed to be listed? 21? Oppose this matter on 30th September. 30th September. What to do? They want it, tag all the matters, whatever reaches will be done. Yes,
My lord, serial number 24 and 25.
yes.
It's passed over, my lords, for the appellants to
Yes.
appear.
Yes, my lord, my learned friend has some difficulty in the afternoon. Course, I is ready. It could be taken up tomorrow.
Yes, 34 and 35 tomorrow.
24 and 25.
24. No, the difficulty is when the court is not accommodating the counsels for a mention on an adjournment, if the court starts doing it for the senior counsel, it's a discrimination. Yes. Tomorrow.
Tomorrow.
Yes.
Learned counsel for the appellant. ಧ್ಯಾನ್ ಚಿನ್ನಪ್ಪ ಸರ್ ಅಲ್ಲ ಜಯಕುಮಾರ್
ಕೇಳಿದ್ದವ್ರು ಅವ್ರಿಗೆ ಡಿಫಿಕಲ್ಟಿ ಇದೆಯಂತೆ ಅಂತ ಇವ್ರು ಕೇಳೋದು ಧ್ಯಾನ್ ಚಿನ್ನಪ್ಪ ಸರ್ ಯಾರಿಗೆ
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು ಧರ್ಮಶ್ರೀ ಅದೇ ಇದು
ಅವ್ರಿಗೆ
ಬೋತ್ ಕೌನ್ಸಿಲ್ಸ್
ಗೊತ್ತಲ್ಲ ಇವ್ರಿಗೆ ತೊಂದ್ರೆ ಇದೆ ಅಂತ ಇವ್ರು ಕೇಳ್ಕೊಂಡ್ರು
ಬಟ್ ಅವಾಗ ಅವ್ರು
ಜಯಕುಮಾರ್ ಎಸ್ ಪಾಟೀಲ್ ಕೇಳಿದ್ರು ಇವ್ರಿಗೆ ತೊಂದ್ರೆ ಇದೆಯಂತೆ ಮಾಡಿ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಹಾಕಿ
ಅಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
230 ಇರೋದ 230 ಇಲ್ಲಿ ನಮ್ದು 230 ಕರೀತೀರಾ ಮೇಡಮ್
purchasers and sought for injunction. Injunction has been granted, my lord, and that has been stayed. My lord, let them maintain status quo, my lord, as on today.
Kindly see the
In the
last,
guise of stay order, let them not.
last date order ಅವರು status quo maintain ಮಾಡಕ್ಕೆ ಹೇಳಿ ಅಂತ ಇದ್ದಾರೆ. Last date ಅಲ್ಲಿ safeguard ಮಾಡಿ.
He has a claim over 5 sites without boundary, without any identification. But we said as far as that is concerned, 5 sites we will retain.
We will not sell.
We will not sell. That's what even the.
Interim order is observed.
Yes, my lord. 15-4.
Lord, may I draw your lordship's kind attention to para number 8 of the impugned order for a moment. Para number
No,
8,
what
my
is
lord.
the order passed by this court?
Please, my lord.
Day of the impugned
15-4. However, it is made clear that appellant shall not alienate or encumber or transfer or part with possession of site number 40 to 44 that may be
According to you,
formed.
which is the property?
According to the schedule, my lord, 101 to 105, as per the agreement.
No, you purchase the property.
I purchased the property.
What is
Only
this?
5 sites, my lord, out of total extent, my lord, 5 sites have been shown. My lord, 101 to 105.
No, the non-alienation is in respect of 40, 41, 42, 43, 44.
No, they are saying, my lord, 40.
Whose case is this, that this property should
It is their case, that 40 and.
May I give the beg? In a unconverted land, without there being any layout, there is an agreement to sell 4 sites in his favor, showing site number as 100, etc. With a boundary of entire land. Those 100, his site is not identified at all.
Without any layout or anything, how that 100 will come, 100 can be
No,
identified?
there cannot be a site.
When is it converted to?
100. It is.
Layout, when the permission is granted.
After the present appellant took over the property, he applied for formation conversion. Then he applied for layout approval. Layout was approved by.
Yours is an agreement of sale.
Mine is, I am an agreement holder. There is an order of injunction against the original defendant number 1, restraining him from alienating the scheduled property. Injunction was granted on 28/5/2018 after hearing both the parties. Subsequently, my lord, defendant number 1, my lord, sells the, my lord, 2 acre 32 guntas in favor of present appellants.
Entire layout, how much is the extent of land?
The 5 acres and odd is the
Entire layout.
Entire layout.
What is the land purchased by you? How much is the extent?
5 sites.
Each site comprising
What
of?
measurement?
6,000 square feet, 101 to 105, as per the original agreement. Now they are, in the absence of any, even according to them, any identification and demarcation, my lord, now they are offering, my lord, 40 to 45. There is an, despite injunction.
Yes, no, yours is a case without any basis. Your property, whatever the 4 sites should have the boundaries. Then you can protect the land.
Boundaries.
Under the guise of this order, how can the entire 5 acres can't be stopped? You don't even know what is your land.
Injunction order is in violation of injunction order, my lord, sale has taken.
No, they will say, I don't know what the senior counsel is going to say, but they will say that you are saying about a piece of land. That piece of land could be between this 40, 41, 42, 43, 44.
Now, even according to them.
Anyhow, that land is kept there, which is that amounts how many square foot?
That it's same 30-40 site.
Let them keep, my lord, preserve
6,000 square feet.
6,000 square feet of land they are not selling. And even as per this order also, you are
let them preserve, my lord, 101 to 105, my lord.
101, there is no such existence at any point of time.
There is no 101, 105 for them.
Now, if we are offered a land, my lord, in a, not in a prime locality or.
No, the difficulty is you can't even now identify which is your land.
But that's why injunction has been granted.
Your land has no boundaries, sir.
Bond in the agreement boundary is shown.
Let's
No,
see,
there is
where
no
is that
boundary.
agreement?
Entire land of 5 acres.
You have agreement?
Yes,
see, where is that agreement?
it is available. There is a small paper book, my lord.
Schedule page number 4.
Paper book ನಮಗೊಂದು copy ಕೊಡಿ.
ಅದರಲ್ಲಿ kindly go to page 4.
Page 4. Yes.
Schedule. The property is situated at Arsikere village, Kasba Obli, Arsikere, bearing 504/3, new survey number 504/3 and 504/1. 5 sites having extent of 30 feet for 30 into 40 feet each. Extent of 5 acre 10 guntas. 5 sites bounded by property bearing 494/2 of Jagadish.
So, all the 4 sites will not have the same boundaries, sir.
It is
Because it was not converted.
This boundary is the
See,
entire
now,
boundary.
Can't even say that this is my land because you don't have the boundaries. So you will be now have to be satisfied with the 6,000 square feet of land, which is already protected by an interim order of this court.
If
But
they,
let
they
it be
want,
identified, my lord.
if
Let
they
it be
want
identified.
No, they have already given the numbers. No, they have, there is a, no, there is a layout.
approved layout.
Approved layout.
For a moment, my lord, paragraph 8 of the impugned order, I will not take more than 3 minutes. Paragraph 8 of the
Who
impugned.
is this unserved respondent?
Now, respondent number 1 is no more. Sorry, respondent number 3, na? 3.
No, the respondents, 2 has to be served.
Ah.
Who is this respondent number 2? Your vendor
Under. He's no more.
is no more. Then is, when he died,
He died
His vendor.
Under.
26/24, my lord. As per
26?
24, my lord, as per instruction from trial court.
Oh, even before the trial court itself.
Yes, my lord. They're informed. I have to file necessary
No.
application to bring.
When is the impugned order? I mean, when is the impugned order passed?
Impugned order is dated 4/4/24.
So he was there by that time.
Yes,
When,
yes.
when is the interim order by this court?
15/4. And,
After
and
that-
I also make it clear, in case they want any other site other than these 5, they are at liberty to talk with my client and identify. Subject to result of the suit, even that we will preserve.
That we will have discussion. I don't know. Discussion.
You're getting a good offer, which the court also will not give. any
Let them
such-
bring LRs of my lord, the original.
It is submitted that respondent number 1 and 2 are no more.
Layout plan on the namagondu copy kotre.
2 is no more.
2 is no more, and the counsel for the appellants seeks time to take steps. This court has already passed an order where an undertaking is given by the appellant stating that they'll not sell 5 plots measuring 6,005. Is it
6,000 square feet.
No, no, is it 5 plots or 4 plots?
4.
5.
5 sites.
5 plots measuring 6,000 square feet. From the impugned order, the rights of the respondents are already protected by this court. It is submitted that for identifying the property and other things, they'll have a discussion on that and come up and will submit by the next date of hearing. Post this matter after vacation on 29th of October. In the meantime, the appellant shall pay process in the R2 you said died.
I will make the application.
Yes.
Cell number 5.
The interim order may kindly be.
Order earlier granted is extended till the next date of hearing. Yes, 5.
5. Manjunath HR.
For the directions of this honorable court, madam. So the copies on the.
Oh, you're referring.
My lord, I appeared for the respondent 2 to 4. My lord, I filed my vakalat today morning. Yeah, the notices were served only on the 17th, and the vakalat was given this morning. It appears some settlement procedure were going on. So now they gave me the vakalat today morning. I filed it today morning, my lord. So I think I got to file my objections.
Yes. When do you want? You have a stay in your favor?
Order is.
There's an interim order in your favor?
Operating this.
At the request of counsel, the respondent, pose this matter on 30th of October. Interim order earlier granted is extended till then. Then what about, you are, you are going to file vakalats for R2 to R4?
I appear for R1. ma'am. I appear for R1.
You?
R2 to 4.
Yes.
And madam,
Yes.
one submission I got to make.
So Mr. So-and-so had instructions to file vakalat
Madam,
for R2
not
to
with
R4.
any authenticity, but I came to know that the first appellant has passed away.
I'll have to verify and take steps.
So this is the
It is
position.
submitted with the land council, the respondent that as per his instructions, the appellant is no more land council.
For one, please.
Appellant one is no more land council. The appellant submits that he'll get instructions in this regard. Yes, next.
Cell number 6.
I appear for the appellants in this.
My lords, appearing for respondent number 4, my lords. I
You'll
request.
file
that-
vakalat?
Yes, ma'am. I'll file vakalat.
So it is submitted that so-and-so has instructions to file vakalat on behalf of R4.
Now the process would be completed. If my lords were to kindly see the orders dated 2nd July, my lords, passed by this honorable court. An order, the trial court had granted an order of non-alienation, which has been stayed by this honorable court after hearing, my lords. Lords, I had taken up a contention, it is a self-acquired properties. We have,
He has to come on record. He has to file his
this order
vakalat
could be
R4.
extended. my
A
lords.
week,
This order could be extended till next
It
year.
will be extended.
No, my lord, before
a
that,
week's
last
time maybe.
Friday, your lordship passed another interim order not to execute any sale deeds.
Oh, this is the case.
This is the.
Then
That is the reason, my lords.
Why
Is that
my lords,
my
you
lord?
are executing a sale deed?
my lords, it is my father's self-acquired properties.
Your
If my lords were to
It
kindly,
has to be heard. It has to be heard.
my lords, next week, my lords.
Then
can
we'll
it-
have it on
Till then, I will not execute any. sale.
1st October.
Please.
Suppose this matter, by the time you file
Please,
vakalat,
ma'am.
well, so-and-so submits that. R4, so-and-so has instructions to file vakalat on behalf of R4. Land council on the last occasion when it is brought to the notice of the court that in spite of an order, the appellants are executing as.
My lords, in spite of order was stayed by this honorable court. Order of trial court was stayed by this honorable.
It is stated that in spite of an injunction granted by the court,
That has been
they
stayed.
are executing the order.
There's no
Executing the
injunction.
sale deeds, the sale deed on 23/9/2024. Due to paucity of time till the matter is heard, this court has directed not to execute any sale deed in respect of the
Deed of conveyance.
sale deed any document in respect of the suit scheduled properties. Today, as the fourth respondent is had to file his vakalat, post this matter on 1st of October. Till then, not to execute the earlier order granted on so-and-so date shall continue.
Layer order shall continued on the stay continued.
No, earlier order
Dated.
passed by this
Order
court,
dated.
not to execute,
Please,
shall continue
One order
till,
will be con-
till 1st. Yes.
Cell number 7. Shiva Reddy KN.
No representation for dismissal tomorrow.
Cell number
Yes.
8.
This matter,
Vaibhav V.
uh,
Gujral.
scheduled property, my lords, is part, is shown in schedule B.
We'll just look at the office objections and
Your-
what is your
document,
submission?
At the page, I produced a plain sketch, my lord. It's at page
File and-
20, 34, 35, my lords. Schedule A is a larger property, Schedule B is the smaller property on which they are trying to build up the
Document to be furnished to verify
I'll-
IA clearance.
I've got a
schedule
sale deed
details.
also. I got my sale deed, which shows the dimensions of my property.
No, they asked so that you have to.
Oh,
file.
that I didn't know, my lord. Other day I complained it
no,
and
no.
I gave my reasons also.
No, no, no.
I given a memo, my lord,
No, no,
not
for
on
this
office
there are no
objections.
reasons. No, they wanted documents to be furnished to verify IA prayer and the schedule of the
I'll produce it
details.
tomorrow, my lord. Could take a day after tomorrow. There is
Ah,
emergency in the matter.
The petitioner
Much of it.
the appellant shall comply with the office objections. And if the office objections are complied with, pose this matter on on 30th.
Sale number 9,
Post after service of notice on R2. Next,
sale number 10,
9 minutes, sir. That matter where your lordship was seized of the appeals from KPID Act, single bench or division bench.
where is the council? You're ready?
Senior is not.
Then it has to go after vacation. Because both of them want to argue on the maintainability of this. That there no it is submitted that at the request of land council, the respondent posts this matter on 14th of October. Till then, the interim order granted earlier is extended.
sale number 10,
What is this council submission with regard to discrepancy in the schedule? Huh? Oh, it's 9. Yes, yes. 9, say, you appear for which respondent?
Respondent number 1, lordship.
2 is who?
Minutes, 2 was the original bank, minutes, who is now represented by the administrator,
Notice to them is necessary?
not we minutes to them. Minute.
Bisuko. Then you should have find a memo that whether it is land council submits that till ascertain, he'll come up with a necessary memo by the next date of hearing.
Please.
Yes,
sale number 10,
interim order earlier granted is extended.
Pawan Chandra Shetty,
My lord, office objection is, my lord, in running page number 90.
Discrepancy
Yes,
in
my
the
lord.
schedule details from page number 90 with
90
page
and,
number 120.
Yes, my lord.
Let's see,
My
where is,
lord,
what is
in-
page number 90?
My lord, in 90, my lord, schedule property, serial number 40, my lord.
Hmm.
In 7/4, measuring 1.19 acre,
Where are you reading it? I'm looking at 90.
running page number 90, my lord, 40.
40,
Property
40,
40, my lord. See, survey number 97/4, measuring 1.1 acre, including food karab, my lord. My lord, boundaries are different, my lord. Kindly peruse 120, my lord, running page number 120.
What is this 90? This is the plaint.
This is the plaint, my lord.
Now, please come to 120.
Yes, my lord. It's an IA, my lord. My lord, in schedule, my lord, same survey number, but the boundaries are different, my lord.
Why?
My lord, it's a defendant number 6 property, my lord. He filed a IA. So the IA, when he mentioned the IA, my lord, that is correct schedule, my lord.
120.
Running
Where
page
do you
number
get 120?
Schedule, my lord. The land bearing survey number 97/4, my lord.
Why the section is there being as if more than the court exercise they're doing it. It is in the along with the in the order in the plaint. How are they concerned? If something is stated now in any of the document, any of these pleadings, then they should raise an objection. Lower court has considered it.
Yes, my lord.
Both are filed before the court. How do it will change now? Office objections are overruled.
My lord, there is
Post
a
this matter
my lord, there
for
is
admission.
there is a delay in filing the appeal, my lord. May I permit it to take hand summons, my lord?
That has to be listed.
Yes, my lord.
Yes, post this matter on 1st October. Yes, next.
sale number 11,
Petition.
This case interim order, your lordship, only 20,000 along with educational fees. It is very difficult for child is concerned.
Last
only-
vacation mediation, we agreed for the 70,000 for child, 40,000 for her.
What is
30,000.
what the court
But
below
they
has
are not-
granted?
They are not agree, they are not ready. We are ready to pay 70,000 rupees.
Both of you start somewhere, how the court will understand. First tell the court what is the order of the trial court. What is the order of the trial court?
20,000.
20,000 to the,
By way of interim order, 20% of the salary to mother.
please
7
come to
and-
the impugned order. It's
Yes,
better I look
yes.
at that order. Yes, page number.
Page number 50, your lordship. So 48.
Respondent is hereby directed to pay monthly maintenance of 20% of the home take salary to the petitioner. Petitioner is who? Wife.
Wife,
And 7.5% of maintenance to the daughter
child.
from the date of petition. Why is this complicated order? Court can as well quantify what is that amount.
Because my, 1,60,000 he is drawing salary man.
Hmm.
Now he is upgraded as manager, chief manager, getting 5
So
lakhs.
court considered his, what would be his enhancement of the salary, so on that he should. What is your salary as of now?
Now 2.5 lakhs.
No,
2.5
no,
lakhs.
no, Your Honor, 2 lakhs only.
Hmm,
Day before.
2 lakhs.
Day
So
before
what is
yesterday, I
20% of
furnished-
2 lakhs?
40.
How much will be 20%? 40,000?
40,000.
40,000 to the wife. Then what is the 7%?
7% it maybe comes.
14,000. So court had granted 54,000 and odd as maintenance
By virtue of.
out
income
of
or
2 lakhs, which he is earning.
By virtue.
What is wrong in it?
20 lakhs.
Mother,
20,000.
mother also is the cancer cervical patient, Your Honor, but now.
No, still you have 1,50,000 with you. Only 50,000 is given for 2 persons. You, your mother, even her ailments also.
that
You have 1,50,000.
Recently, she got operation spinal cord, my lord. That
So
he is-
whatever it is, you can
We are
spend for
ready
her
to-
also.
we-
No, spend full 50,000 for her, but two wife and the daughter or son, it is 50,000. Spend 50,000 for your mother. Still you are left with another 1 lakh.
That's why, next date of hearing, I filed my,
How many times these matters will
Next.
come?
next date of
For
definitely.
years together, this going on.
The child is studying, my lord, in.
We are
grade school.
agreed
Are
every,
you paying or not?
everything, my lord, everything we are,
50,000 by virtue of entry. But
Ev-
school fees and.
school fees, everything we are ready to pay, but they are not simply drag on the matter in
Day
mediation
after
also.
time.
Since the date also we are ready to pay, that is the pending amount
You are
is the
ready to
30
pay,
lakhs.
is not ready to take.
No, no, we are ready to.
Yes,
take.
yes,
But,
yes, my lord. Yes, they are not ready to
take.
They are simply dragging.
Now I'll pass an
last
order, you tell the
13
court
years,
what is that you're paying.
last 13 years,
No,
run
no.
down.
Tell the court, why are you paying after the order passed by this court, the 20,000 you're paying?
Yeah, regularly.
What about the school expenses?
school expenses? Also, they are not filing any.
No,
See,
no, we
simple.
have
One,
every month
if you,
sending
if
message.
you see the,
Message we are sending. But
Man,
we are
not
not-
message.
Pose this matter on Thursday. By that time, the counsel for the
After
respondent,
vacation, please.
no. The
Please.
counsel for the respondent shall place before the court how much is the amount spent towards the education of the children. And appropriate orders will be passed directing the petitioner to pay the amount. Yes.
Number 12. Ilfana Nazir.
My apologies, my lord. The memo of calculation, lordship permits me.
Who is this? You file the memo. Who filed the memo of retirement?
Get filed it, my lord. I have to give.
of hearing,
Huh?
filed the memo.
I have to file the memo, my lord. Respondent in
No,
140.
no. Memo for retirement filed by the advocate for respondent.
Shobha Bhavik Katfi. I'm appearing for Shobha. Bhavik.
Oh, you have, after that you filed wakalat also.
Yes.
Hmm.
In January,
Give that.
Please.
What's that, that memo will allow?
my submission matters. I have filed a memo
No, it is not coming up for, why it is coming up for order says not for argument.
My lord,
Only
may
for this. office
I
of
understand,
the
my lord,
action.
they
My
should
lord,
have filed it
what if
before
I can
time. This is the reason, my lords. Every
Kindly
time.
post it. In the meantime, what I have been paying 7,000 rupees per month.
1 minute. A memo is filed, seeking retirement. A memo is filed, memo of retirement is filed by the respondent. And already Mr. B.R. Dattar has filed his wakalat also. Hence, so and so, Shobha is, is permitted to retire from the case. Next, the counsel for the respondent had filed a memo of calculation. What is that?
Please, my lord. Court officers.
And what is that DD?
DD is for the 9 months, 7,000 rupees, which I have to pay from 1st of January till today.
That order
September, I am paying it. my lord.
That order is set aside. This is the second round of litigation before your lordships. In the first RPFC that was,
This is a RPFC of
please,
2021.
please.
What is the
There was an
interim order in
earlier
this?
order wherein initially when the petitioners moved the court,
No. What is the interim order in this?
interim order, my lords, in fact, the appellant himself, in fact, has sought for an interim order of stay because the order passed by the trial court is
No interim order in this case.
There is an interim order wherein the execution proceedings have been stayed.
For state, no conditional order.
No conditional order. In conditional order in the sense, my lords, what happens is he's supposed to pay 25% of the maintenance amount. Apart from that, what has been granted in the first criminal miscellaneous, 125 proceedings, he was supposed to pay 50%, my lords. Now, what happens here is initially in the first order, my lords, was 7,000 was to be paid. 7,000 each was to be paid to the petitioners. That is to the wife as well as the daughter. Now, then we 7 plus 7 is 14,000. Then we move this honorable court. This honorable court says, no, you file a modification. Then we file an application seeking modification wherein 10,000 and 8,000 respectively.
Well, I'm not able, there are
Please.
two petitions.
One they have
wife,
challenged,
one
one I
by
have
the
challenged.
husband.
Both are.
Wife has questioned the quantum.
Please.
Husband has also filed it.
He's questioned, he stated that this should not have been granted.
You are appearing for the wife.
I am appearing for the wife.
What was the amount granted by the family? court?
Initially was 7,000 and 7,000. Thereafter, this honorable court directed me to approach the same court by way of a modification. In the modification, what the trial court does is, trial court grants 10,000 and 8,000.
No, for another 4,000 is increased.
Please, my lords. Now
That is now, it becomes 18,000 now.
Please. He's the owner of a bar that he runs. There are 2 bars. In fact, there is the findings of the trial court also states that he's earning more than 1,20,000. Yet the trial court grants only 10,000 and 8,000 to the wife and the daughter respectively. I was saying that order before your lordship, stating that the quantum should have been increased. Looks good. And my lords, the arrears
What is this memo of calculation?
Please. The last date of hearing, my lords, when I have filed a memo of calculation, wherein I state that the arrears are 14,43,500. And my learned friend files a memo and he states that
No,
my lords, he
where
does
from
not
you're
state what they-
calculating the 7,000?
Yes.
It would have been 7,000
Yeah.
plus 7,000.
In the earlier round of litigation, RPFC 180 of 2016, the stay was subject to 25% of the deposit of maintenance arrears for 3 years.
That's over.
1 minute. That is over.
Mm.
So that final order, when it came, they confirmed this order. And I was directed to pay 50% of the amount till the matter was disposed of by the,
Where do you get that order?
that order, my lord. Yes. 180,
So 50%
I'll
of that would be 9,000.
no, 7,000. That was 14,000 earlier. Earlier, 7,000. That
No,
became,
that order is now, that worked out.
that is why that got merged with the High Court order.
Yes.
And the High Court
Has
remanded
remanded the matter.
the matter. There, instead of filing an application under section 127, they filed an application under Order 6, Rule 17 for amendment of the petition. And that,
Have you questioned it when that amendment is
yes, my lord, that is exactly what the learned judge said, that you are not questioned it now, you proceed further. So we proceeded further. But there is a bar under the act, my lord, wherein section 10 itself says, 10 of the act may kindly be seen, my lord.
at an appropriate point of time, when you have an opportunity, you don't
That
question
maybe
it.
what your lordship says, I agree, but the bar, there is the legal bar, my lord.
No, why have you not?
The Family Courts Act.
Have you not brought?
I have taken it now. Now the contention.
How
has been
can you
taken.
take it now? Why did you waste all
but
the time of the court
there
with
cannot
all
be
that?
My lord, there cannot be a estoppel against the law. Kindly see section 10, procedure generally. So after remand, can they file an application of CPC
Yes.
in a criminal proceeding, my lord? Here, section 10(1), subject to the other provisions of this act. Kindly see, my lord.
Had you questioned it at an earliest point of time?
I should have done it.
All this could have been avoided.
Certainly, my lord.
Which year is this? This is of
21.
2021.
21.
Now the court has to decide this and now again send it back.
My lord,
How many times it will go back?
Precisely, my lord. Therefore, my lord, if your lordship would kindly consider it, now that from 14,000, they have made it 18,000, my lord. Now, my submission is that whatever there is a bar which is being run, which is a partnership firm, all those matters can be gone into. But at present, my lord, may I present the 7,000 rupees which I have been paying, that amount for the last 9 months. Your lordship may kindly hear this matter and decide.
My lords, mere wrong
Because there is
provision
a
of law,
totally-
my lords, the
We'll hear and pass orders.
Please, my lords, mere wrong provision of law is no bar to
No, that.
deny relief,
that's
my
not-
lord.
But
That
the
will
court has to
doesn't
pass
state.
an order.
Yes,
Take
Please,
yes.
what is the amount?
This is 63,000, my lord.
For an amount
63,000.
of rupees 63,000, a DD is handed over by the land council appearing for the wife to the husband, to the council appearing for the wife. He is now in an RPFC of 2021 is questioning an order of amendment of the pleadings by the parties before the trial court. And trial court, this court will hear that and will pass appropriate orders. Pose this matter on November 11th.
My lords,
Please, my lords.
my lords, let there be some continuity in making payments.
And
Lords.
we shall
Again, they
do
won't
such
pay
time.
for, they'll not pay
Month,
for another
every
9.
month.
No, definitely I'll.
By
pay, my lord.
5th of every month,
Only
we
because
shall
this matter is
continue to
listed
pay
there.
the amount.
My lord, my difficulty is, my lord, when I go to pay there, my lord, they
Yes.
don't allow me. They refuse it, my lord. I'll pay it here.
Why?
They refuse it. My difficulty.
Then transfer to her account.
Please, let them
Counsel
give
for the-
Let them give me the account number.
Counsel for the wife shall furnish the details of the bank account, bank details to the counsel for the husband. Yes, next.
Please, my lord.
Obligements.
R.S. Secretary for petitioner. N.G. Sridhar,
My lord, appear for the
A. Ravishankar.
petitioners.
Yes.
This is my lord, Lok Adat matter. Lordship direction, my lord, the reports are submitted. But I could not get the report. I applied for a copy.
How many days this will go on like this?
No, I never took time, my lord. It so happened.
No, I'm not telling that you have taken time. I'm saying that some order that which is passed in the year 2016. Now, even before this court, it must have come so many occasions.
No, before your lordship
Uh,
only, my lord, the records were.
The court of the second additional civil judge has conducted regular Lok Adalat on 22/12/2015 within its jurisdiction. So your case that on that day no Lok Adalat is conducted is without any basis. That report is before this court, Karnataka State Legal Services Authority.
Earlier, there are two other reports, my lord.
Yes.
I will take all the reports and make my submission.
My lord, in
Any date?
fact, I'm sorry to interrupt.
I have applied and it is not given so far.
No, all that you have to do first and then file a writ petition. Not that, that's not the duty of the court. When you're questioning on some kind of fraud and other things you're alleging, for that you have to place the material before the court. No, court keeps on asking, and now there is a report before the court.
The report is received recently and therefore.
No, we will pass orders. We'll not adjourn this matter. It shows that there is a Lok Adalat. On the face of it, I do not find any reasons to believe that she was not part of it. And I will observe that and dismiss this writ petition. Give that. Let it
Lord,
be.
And even the translation.
English translation, my lord.
Of what?
Annexures, my lord.
Even it makes it very patently clear that Lok Adalat was indeed held. She asserts that. And what she says is, she was unable to understand what was explained to her by her counsel and.
No,
by
but
the
how can she take two inconsistent stands?
Exactly, my lord.
First of all, it's your case, as per your own averments, that there was no Lok Adalat held. And you say that it's a Lok Adalat held, I'm not able to understand. Are you permitted to say, let's look at the first writ petition. What is your case? Let's come to the application.
My lord, I have produced the application file. And
No. Let's see from your petition. What is your specific case for alleging fraud and other things?
At page 18, my lord.
Page number 18.
On the basis of the certified copy issued to me, my lord, I have made a submission. Ground raised, my lord, at page 18, that Lok Adalat was not constituted.
Please come here. No.
Page 18.
Where is the main writ petition starts? How can they do the tag on the top of it? Absolutely no. And then writ petition should be first. Other documents should be in the back. Something is wrong with the registry. Even the court has to look at the file. Where is it? Then please come to and please tell the court what are the facts. Where
Facts,
did you
my lord.
specifically say?
My lord, the facts of the case are.
No, not all the facts. What facts you have
Relevant
stated?
facts.
No, I remember all the facts. When it comes to your petition, this writ petition,
Please.
where did you say, what made you to come to this court? Only that portion of the order.
Yes, my lord.
the
That your
pleadings.
lordship find at page 18, the contention taken, the grounds urged, my lord. On the basis of the certified copy, page 18.
Para number?
Para number 34, my lord.
Yes, please. Sir.
That the joint memo dated 22/12/15 recorded by the Lok Adat of second additional civil judge and JMFC Hassan is not in accordance with law, having regard to the admitted facts on record that
No,
on.
not this. You are saying that no Lok Adalat is
Yes.
held. Where is that?
That is.
Which para?
Same para. Constituted and the advocate conciliator was not present.
Looking at para 32, I don't find it.
34, my lord.
Huh.
Grounds, in the grounds, my lord, page 18. This was the contention taken.
Lok Adalat was not
Not
constituted.
constituted.
No, please come to your, this translation of our evidence. Please come to that.
In the affidavit, application and affidavit, my lord, I have stated that I was not well. I could not know what has happened. I was asked to sign.
However, I have been insisted to come, and on that day my son had gone to college, and in the afternoon I came to court in the auto on that day in spite of suffering severe typhoid illness and was not in a position to speak. I had gone to Adalat, and there some persons were sitting, and my advocate got signatures to some papers already typed. I was not in a position to understand what my advocate told. So this statement of hers and your para number 34, how are they going together?
Para number 34, my lord, is based on the records of the case.
No,
Yes,
you said that no Lok Adalat is done on that day.
yes,
That
my
is,
lord. Yes, my lord.
from which records you will get that no Lok Adalat was done on that day?
That is my certified copy, your lordship may kindly peruse.
That is not signature, certified copy is
No
the,
signature, therefore, conciliator, advocate conciliator was not present. And I have said in my application, one person was sitting. I have said in the application, the next paragraph. my lord. Then,
your statement of that no Lok Adalat held, is it altogether a different statement from what you are submitting now that? Now, for example, if that order is not signed by the advocate conciliator and it's only by the judicial
please, sir.
thing, then that you are accepting that it is held. But it is not that order copy which is furnished to you is not in accordance that's what you can say. But you cannot say that Lok Adalat itself is not held.
My lord, then my further contention is kindly
No,
peruse.
first you complete this contention.
No,
With
no,
regards
this-
to Lok Adalat
this
not being
contention-
done.
This contention, my lord, based on annexure K at page 89. That there was no signature of the,
By that you can say that there is no, and having attended and signed, you say that no Lok Adalat is done on that day.
then my lord, this Lokarat, even if my lordship
No,
consider.
not even if,
Yes,
when
madam.
these kind of, when you allege so
Lokarat,
many
even-
things.
No, if there is a Lokarat, my lord, lordship kindly see how it has been, proceeding has been taken.
No, we will not go to that. We will be first on the point whether Lok Adalat is done or not. How can you come before the court and say that there is no Lok Adalat? If you say it is not signed by so-and-so, it is defective, that is a different aspect.
Please.
You yourself have taken a stand that no Lok Adalat is done, just like that some document has come into existence or that order has come into existence. And you yourself will say, I went there, so many things have happened, you yourself have signed.
My lord, with
But
that,
for the purpose of getting over an order, if the litigant is permitted to make these kind of statements and the court starts entertaining it, there is no end to this.
my lord, in fact, my lord, with great respect, my lord, the proceedings of the case show that there is no reference, no request was made.
No,
No
that is on a defectiveness of an order. But
That-
what are you saying? What your contention is, no Lok Adalat is held, nothing has been done, you are not aware of anything. Finally, some order came to be passed. But what is the statement of yours that is saying?
The statement of the applicant is that she was not well and she could not know what happened on that day.
That is ignorance of law is not it's not an excuse.
The
You are
procedure.
having your advocate, if your advocate has misled you, then file a case against
No,
your
no, I am
advocate.
not. My lord, the procedure has not been followed.
No, that is a secondary submission. First submission is with regard to not being, the Lok Adalat is not held. So why not the court issue the perjury proceedings against this lady for making these kind of statements before the court to get over an order?
No, it is not so, my lord.
No,
Not so.
please tell your client, the court is very serious on that. Let her withdraw this, or else I'll record your other contentions, this contention also, and I'll direct to initiate perjury proceedings against your client. Nobody can be permitted to take the course of law for granted. Yes.
My lord,
This matter on
the
1st of
contention
October.
taken, my lord, your lordship will kindly see.
She has to substantiate the first contention. I will not go to the second contention at all. Pose this matter on 1st of October, by the time the counsel for the petitioner shall get specific instructions, or else appropriate orders will be passed on that day. Yes.
Cell number 14. Cell number 14. Ira JK.
And for the petitioner not.
What is this? Memo filed by advocate for petitioner dated. What is this memo?
With regarding revalidation of the DD, my lord.
What happened?
Last occasion I have,
You have sought for time.
please, I have
Okay.
sought for the time that the bank peoples are asking the letter from the beneficiary of the DD. That they have endorsed on the representation given.
I said, you come up with an application.
I have produced, my lord.
What is that?
Memo. To the beneficiary, please send us original banker check along with your letter for revalidation. We will.
No, how will they revalidate when the person is no more also they will do it?
No, they are requesting the beneficiary of the DD. Beneficiary is the Registrar General of High Court of Karnataka, Bangalore.
He is not the beneficiary.
No, in favor of the DD was drawn.
His favor.
Please.
Ask the Registrar Judicial to come. The chambers will see. Yes. Next.
Cell number 15.
Petition. Correspondent. The mother said she'll hand over custody for a month.
Huh?
Mother said she'll hand over the custody of the child for a month. The affidavit was to be.
Take that. No, what are the matrimonial proceedings that are
It's a
pending?
divorce petition and a petition for custody filed by the husband, which are pending before the family court. But the matter is referred to mediation. I think we will be able to resolve this.
When they will appear?
Uh, The child has exams, they say, from 27 to 9th. So
No,
after
no.
9th,
When,
here they say child has exams.
from
28 to 3.
Saturday. That is, I think there is a stamp on this. I'm not able to see. It's from
28 September to
9
9th of
AM
October,
to 9 AM to
2 p.m.
2 PM till Monday,
Monday,
Monday to Friday.
Monday to Friday 9 to 4 and Saturday 9 to 2, 9 AM to 2 p.m.
Her exams are starting from 20th September.
28 till 9th of October. So any date after 9th October, you know, when she has holidays, it will be easier for the father to go to the mediation center.
After vacation?
14?
Yes.
14th of October.
No holidays for the mediation center?
14th, the courts reopen.
Court reopens.
On 27th, they're supposed to hand over the custody of the child. That let the mother not bring her to the father's house and
That is not
the
possible.
first
sir.
time.
That's not possible.
Or in the complex, apartment complex.
Before the chamber.
No, how do you want it?
In chamber, my lord, that is the better thing, on 27th.
Why should the court doesn't have to
Chamber
be?
court chamber
Yes,
from here.
yes. That is the better, my lord, please.
27th is Friday. Friday, I won't be there.
Oh, any public place in a mall, playground.
You'll hand over to the registrar judicial. Why you are anticipating,
I think.
or picking her from the school, from our place is also like.
That's
you
why I
have to
thought
do-
if the mother could drop her off in a mutually convenient place.
Wherever the mother says.
Wherever the mother prefers.
In Whitefield.
Huh?
Whitefield.
No, she stays in Whitefield.
Yes.
Where will she give the custody of the child to the father?
I will intimate. That is-
They'll intimate. to.
I will intimate him.
Mm.
No issues.
On 9/9/2024, it is submitted before the court that the mother is ready to send the child to the father between 27/9/2024 and 31/10/2024. Now it is, now the dates have changed.
Mhm.
There, on that date was said from 27/10/2024.
Yes. 2024. Yes, my lord.
No, that's not this.
The affidavit.
Yes.
They will drop back on 31st because Deepavali is on 31st and 1st. So one day I can spend, Monday they can spend.
No, any of the affidavit is filed on that, but Deepavali will pass a separate order.
Very well.
She said it is from 9/10/2024, starting from during that time, that minor daughter can stay with the father till 27th. So according to her, from 9th to 27th, she can stay with the father.
No, sorry.
The father between 27/9/2024 and
I'm sorry,
30.
not from 28th of September to 27th of October is what they have mentioned in the affidavit.
No. 27th of September to
I
27th.
don't know, what is that, after the exam, Dasara holidays will be starting from 9/10/2024.
Lordship will
No,
check this.
9/10/2024
Yes.
to 20/10/2024.
Yes.
So during that time, the minor daughter can stay with her father till, from 9 to 27th October.
From 28th September is what she says. Your Lordship may read the affidavit. Not. At present, she has midterm exams starting from 28th of September, ending on 9th of October. I further submitted the request of the school management to take the online exams for which the management has permitted my daughter to attend the online examination. The link will be sent by the school on each exam date. I will intimate the dates and link to the petitioner. That means the daughter is going to be with me during that time.
Yes.
But that is what the mother is saying.
Yes.
From 28th September until 27th October, daughter will be with the petitioner.
It can be from 28th September,
That's what she.
27th September to 27th October.
October, yes.
1 month.
What did you write? Hmm. 27/9/2024 till 31/10/2024. And she also said wants to settle all the pending disputes between the parties. And also she'll file an affidavit in that regard. And also parties will exchange their terms of settlement. Will come up with an outcome after 2 weeks. Accordingly, this court has adjourned the matter and directed that the affidavit shall be filed by 10/9/2024. On 2-3 occasions, the same was adjourned at the request of and counsel of the mother. Today, the affidavit is placed before the court. The mother in the affidavit has stated that the daughter is admitted into Vaishnavi Public School. for third standard. School timings are from 9 AM to 4 PM till Monday to Friday, and Saturday 9 AM to 2 PM. At present, she has her midterm exams starting from 28th September and ending on 9th October. She requested the school management to take online exams, for which the management has permitted the daughter to attend online examination. The link will be sent by the school on each exam date, and she will intimate the dates and link to the father. After the exam, Dasra holidays will be starting from 9/10/2024 to 20/10/2024. So during that time, the minor daughter can stay with her father till 27th of October. And it is also again reiterated in this affidavit that she is ready to settle the matter amicably. It is stated that for the convenience of the minor and well-being and welfare of the child, he can continue his visitation rights and take temporary custody, such as in school vacations, video conference chats, normal phone call. And in case, during the temporary custody, in case of emergency, the mother or his counsel shall contact the father or his counsel. Why is his counsel should contact? The father or his counsel shall contact her or her counsel at any point of time. In the light of the affidavit filed before this court, the mother shall give the custody of the child, shall hand over the custody of the minor daughter on 27th September at a mutually agreed place.
Family court not apparently.
Yes.
At the family
That's
court, in the premises of the family court. And the father shall hand over the daughter to the wife on 27th of October in the family court at 4 o'clock.
Yes.
At 4 o'clock, and this time is also at 27th also 4 o'clock. Not 27th 4 o'clock, and again 27th October also at 4 o'clock. Next one, it is submitted that both the parties want to settle the matter. Hence, the parties are referred to the mediation center, and both the parties shall appear before the mediation center on 14th of October, and the registrar judicial at 3 PM. And the registrar judicial is directed to communicate the same to the mediation center. Next, what were you saying about Diwali?
The father's name is not entered in the school records, that because of, since he's going to have a custody, to communicate with the school to drop her off.
That's why she has made the arrangement for online exam.
That is only for examination, but thereafter, for 1 month, 1 week after the vacations also, I have to drop her and pick her up from school. So his name may be
They will
entered in.
coordinate both.
Yes.
The next one, the mother shall enter the particulars of the father in the school records, and also father shall have the access to all her educational details during the custody, during the time the father is having the custody of the minor daughter. Next, what are you saying about Diwali?
No, 31st and 1st, there are 2 days, not Deepavali. So one day, let the father and his family spend time, because mother stays alone, not with the brother. I stay with my parents, sister, all of us. It's a joint family. So one day.
That one day we'll record. On 31st or 1st?
31st.
31st, on the eve of Diwali, the father can have the custody of the child on
31st, I'll pick her up and drop her back on 1st morning.
31st morning. He shall pick her up from where? From a mutually agreed place, and shall drop her back on 1st morning by 10 o'clock. Pose this matter on after the mediation, it will come.
May I make one request? Sorry, Lordship, will not mistake me. It's only on account of your Lordship's efforts and initiative that we have been able to arrive at the situation. May I request that the matter be part-heard? Only from that purpose. I privilege not for your Lordship to sign off on this.
Part-heards from Dharwad. Pose this matter as part-heard.
Obliged.
Sign it.
Yes.
The respondent advocate is permitted to comply with the office objections. He has to sign those advocate, give him.
Much obliged.
Next date, after the mediation report is, then the matter will listed.
Page to page. Cell number 16.
Lord, office objection is, Lord,
Huh.
application along with affidavit to be filed. Lord, it's in 125, one application, which doesn't have affidavit, Lord. That is the office objection, Lord.
Office objections are overruled. Post this matter for preliminary hearing. Yes, next.
Number
Lord, may I
17.
request for?
No, not affidavit. The petition will be the details. No, you're seeking interim maintenance. You have to file a petition for that.
Lord, 125, one doesn't have a affidavit.
Not affidavit. Petition is there
Petition is there.
that you have filed.
That I have filed as
Objections are
annexure
also
B.
filed.
Lord, objections are also filed. Objections are also
Huh.
filed.
Then typed copy of index to be furnished and filed correctly. That you have to comply.
Lord, annexure D, Lord, I have already furnished, Lord. Annexure D typed copy
No,
is there.
as far as objection number 2 is concerned, has to be complied with. Objection number 1 is overruled.
Lord,
uh,
objection number 2 done, Lord. It's already complied, Lord. Typed copy of annexure D is already on record.
Typed copy of index to be furnished, and filed correctly.
I'll file.
Yes, to be complied with, post for, if the same is complied with, post for preliminary hearing on Thursday.
Much.
Yes, next.
Cell number 17.
And for the respondent.
You're appearing.
I am for respondent.
What is your name? Give the name. So and so submits that he has instructions to file wakalat. The objections of,
Office submission is that my affidavit is to be filed. I
Okay.
filed it.
non-filing of memo for having taken out notice, you are appearing.
Yes.
So that's not required. That's what the court is saying. The counsel for so and so submits that he has instructions to file wakalat. Office objections are overruled. 19. As far as this is 18, 18.1. No, office objections are overruled. Post this matter for admission.
Serial number 17, Miller, for 17.
Huh?
17.
17.
It's not 18.
No, not 18.
Oh, I was looking at 18.
Respondent has to file affidavit, they have filed it.
I filed.
Complaints of office objection raised on statement of objection dated, that is, you have filed the affidavit. It is submitted by the counsel that he has already filed an affidavit and he has complied with the office objections, and he has also served a copy on the counsel for the petitioner. He has posted this matter for hearing, preliminary hearing. Next 18.
Interim order maybe.
Interim order earlier granted is extended.
They have falsely submitted to Supreme Court that they are stating that.
I said post it for preliminary hearing. It will come, we'll hear the matter.
Date.
Will come on Thursday. If not Thursday first.
Okay. Cell number 18. Sharat Gowda, GB. For the petition, my lord, will file to file wakalat for respondent.
So and so has instructions to file wakalat on behalf of respondents. Post these two matters for preliminary hearing. Yes, on first. Yes, 19.
Cell number 19. Cell number 19.
No representation for dismissal tomorrow. Yes, passovers.
Cell pass over list number 1. Cell number 15. List number 1, cell number 15.
Serial number?
15.
1-5.
Hmm. Hmm. Yes.
My lord, may I kindly see, this is a defendant's appeal.
Hmm.
There were two IAs. IA number 1 was filed under order 1 and 2 by the plaintiff respondent.
Sir?
Plaintiff respondent for the order of temporary injunction.
What is the injunction? Not to interfere. Hmm.
And IA number 2 was filed by me under order 39 rule 4. For vacating an ex parte entry. order.
Understand? Yes.
So his IA came to be confirmed.
Yes.
And my IA came.
What is the suit for?
Suit for bare injunction.
What is the case of the plaintiff?
Case of the plaintiff, if you want to kindly see page number 23, Annex B. Plaint.
Yes.
Page number 24, para number 3. It is submitted that the plaintiff is the absolute owner in lawful possession and enjoyment of the property. Site number Old Toll, new BBMP number 437, carved out of property bearing bearing number 48, Kata number 17, 18/78, measuring east to west 30 feet and north to south 40 feet, totally measuring 1,200 square feet, situated at 8th Cross Road.
No, whatever they're saying, no, which is chamber, we'll ask him to just find out what is the procedure. Yes.
So he claimed that he acquired the same under a gift deed dated 27/1/2012, registered as so and so document before the sub-registrar Krishnadapura.
Yes.
Para number 5, Your Honor.
Yes.
Para number 5. It is submitted that originally the scheduled property carved out of survey number 78 of Kaudaspura village belonged to Bettercoat Muniappa, and he enjoyed the said property as an absolute owner during his lifetime. This is important, Your Honor. After the death of Bettercoat Muniappa, his legal heirs and his wife partitioned the joint family properties by virtue of a registered partition deed dated 3/1/2008.
Yes, I have seen. Please come to the written statement.
Written statement, Your Honor. Written statement, I denied all those. If Your Honor, kindly take to
38 onwards.
Page number?
40
onwards, 30.
para number
Read from para number 8.
Para number 8. This defendant submit that the land in survey number 8 of Kaudaspura village, measure 4 acres 21 gundas, was absolute property of Abaya. Same they have also admitted in the plaint. Sri Abaya during his lifetime in 1980, along with his children, formed a private layout therein by forming houses of different dimensions with amenities in phases. The area was then coming under the jurisdiction of HA Sanitary Board and was assigned the Khata numbers to the sites formed therein. Site formed therein are partly sold by Sri Abaya during his lifetime, along with his sons, Sri Anand, as well as Sri Jagannath, and the remaining sites by which his sons, by each of the sons, including the father of the plaintiff and Jagannath. Now, defendant submits that the site number 12, measuring east to west 40 feet, north to south 30 feet, north to south 40 feet, in all measuring 1,200 square feet, situated at Kaudaspura village, Kayarpuram Hobli, situated at...
So you are an agreement holder.
No, Your Honor.
Then sale deed, first agreement. Then the
was,
sale.
Document number 1 is 14/12/1987 sale deed.
No. Come to para number 11. 11 speaks about.
Yes.
You have entered into an agreement of sale on 10/6/2019.
Yes. 10/6/2019, I have entered into an agreement of sale. Now, Your Honor, may kindly see the COVID-19 has spread out. And then page number, next page number 44. This defendant has paid the entire sale consideration as agreed upon, and the possession of property was.
Your sale deed is dated 26/2020.
20th June 2020.
Yes. And the plaintiff's sale deed, gift deed is dated 27/1/2012.
2012. Now, Your Honor, may kindly take that plain this thing gift deed I produced at page number 56. 56, if Your Honor, kindly see.
Now, before we go into the documents,
Ah.
now I want you to please come to the order, impugned order. Now, the facts I have understood, in
Yes.
that we'll see the order.
Imputed order,
Para 11 onwards. Page 19.
Please read from the reasons.
reasons. Point number 1 to 3. It is first to note that the plaintiff has filed the above numbered suit against the defendant for the relief of permanent injunction in respect of the suit schedule property bearing old site number, old toll, new BBMB number 437 carved out of property number 78. Kata number 18/78 to an extent of 30 feet into east to west 30 feet and north to south 40 feet. Situated at Kazakhstan.
What is this voice number 3974 of 2008?
Your Honor, they have filed many cases against all the site owners. I produced some of the
No, no,
judgment.
no. What is this I'm saying?
This, now what the plaintiff contends that, see, in another case, we filed so-and-so against one of the site owners, therein an interim order of injunction is
No.
given. So hence we are entitled for
No.
that order.
All that not is his contention for the factual understanding of the court. Voice number 3974 of 2008 is filed by the plaintiff.
No.
Against his third party.
Yes, the 2 line before that, the learned counsel for the plaintiff vehemently argued and filed a memo with a copy of a judgment passed its voice number 3974 of 2008 dated 10/1/2004 for the relief of permanent injunction filed against one Naranaya against Anand and others in respect of similar site in survey number.
So how is this connected? That's what
It
I'm
is
asking.
not connected.
What is it?
But that is, Milad,
It is not connected.
We'll ask him.
Milad, some sites being, the sale it pertains to, Milad, some sites being fabricated. Milad, I filed a suit against that particular person seeking for
Who
permanent
is this
injunction.
Narayanaya?
That is in respect of one, Milad, they created the documents in respect of survey number 78. In respect of one site. Against him, I filed a suit by virtue of the.
You are Narayanaya.
No, Milad. My opponent was Naranaya. That suit was decreed in my favor.
No, it says one Narayanaya filed against Anand. You are the defendant in the suit then.
No, he is the plaintiff.
That's
He
what
is
it
the plaintiff.
appears from that. Not in this suit. In the earlier suit.
That suit, Milad, site was created. Sale it was created in respect of one site, claiming that.
That I understand.
That, Milad,
You
they
are
filed a
plaintiff
suit
in this-
against me. That
That's
suit
what
was
I'm
dismissed.
saying.
Suit was dismissed. Dismissed.
Yes,
By holding that I am in possession of that particular site.
yes.
That
It's a
document
suit for
of-
bare injunction.
That suit was buried.
Yes, read further.
Next para number 9, my lord. Record received that considering the material available on record, on the date of the suit, the then presiding officer CCH 14 granted an interim ex parte injunction against the defendant. In view of the urgency, as claimed by the counsel for the defendant, he got advanced the case and filed the WS memo of adoption to consider the content as objection to IA and also filed IA number 2 under Order 39 Rule 4 CPC stating that the plaintiff has filed the suit suppressing the material facts and obtained ex parte order of injunction and thereby obstructing the defendant, stating that he has secured the property under the registered sale dated 26/2020 in possession of the same and in possession of the same. In this regard, the learned counsel for the defendant vehemently argued, laying upon the decision reported in 2010, 1 SEC 689, prayed for allowing IA number 2 and vacating the interim order of injunction granted on IA number 1. It has been held in the by the Apex Court that in the rescission referred supra, the order to obtain an order of injunction, party has to show prima facie case to go for trial. Balance of convenience in his favor and irreparable loss.
When was the injunction granted?
But 6,
It's party, I mean.
5,
interim
6,
injunction.
2020.
Huh?
5, 6. But 5, 6, 2020 injunction was granted against the particular appellant.
And
the defendant.
there was this agreement of sale on 10/6/2019.
19.
Till it is on 26/2020.
After the interim order.
you obtain sale deed after the interim order. He was notified the grant of injunction by the concerned court against the defendant. Immediately you obtain the interim order. Immediately obtain the sale deed. When the interim order is operating against him, by claiming unregistered agreement, he claims that he obtained the sale deed.
No, originally his vendor was.
Vendor, my vendor is not a party. He never filed any case against my vendor.
Who are the defendants in the suit originally?
Only defendant, appellant only, not against other person.
Oh, as on that it was an agreement of
No, it was
sale.
agreement, claims to be an agreement holder.
Then thereafter he has taken a sale deed.
He has taken the sale deed, existence of the interim order. His vendor is not a party. Only the appellant is a party before the trial court. We sought for injunction against the appellant only.
Yes.
By misguiding to the court, he has taken the sale deed, though he was served, gave it that compliance of it was served.
This is totally wrong. Your Honor, given the caveat, copy was never served.
Not caveat, compliance affidavit, compliance of
That also, it was never served.
Yes.
If Your Honor kindly see, my IA number 2, the affidavit, Your Honor,
No, no, all that not necessary. I'm not taking into consideration his submission. Now, please argue what is wrong with the order.
No, Your Honor, may kindly see what it says. In this connection, para number 13, if Your Honor, my lord.
I've read the order. You can make your
No,
submission.
I have produced that citation itself. What it says, now there is a, if Your Honor kindly peruse that document also laid upon by the plaintiff. For a moment. He says, he acquired the title under a gift deed. Gift deed is at page number 56. Your Honor, I kindly have a glance of it. Page number 56, my lord. Before that.
There are different numbers, I don't know. 135, 55, 132, 46. Which number has to be looked into with a blue ink or black ink?
Blue ink. Number of cases are filed.
50?
56. Immediately before that. Now, Your Honor, may kindly see, this gift deed contains almost 10 items. It's not on site. Now, suit schedule property, Your Honor will find at page number 71.
Yes.
Item number 10. It is not one site. There are two sites. All that piece and parcel of vacant site bearing old number 12 and 13, new BBMP serial number 47 carved out of property bearing survey number 78. So and so. In 8th Cross Road. Your Honor, may kindly see, there are two sites. Next document, Your Honor, may kindly see, Hatha. At page number 73. This Katha is also in respect of two sites, that is 60 by 40, 18 by 17, 78, 12 and 13. Now, next document what it lies is, Your Honor, may kindly see, tax paid receipt for the year 2015-16. Next one is 16-17, 17-18, 18-19, 19-20. This all created on same day, 13/2/2020. If you want to kindly see.
No, that has to be decided by the court.
Whether
it is created or it is, if it is granted.
Yes. Now, Your Honor, may kindly see the next document. Now, the grandmother claimed.
Just before that, you tell the court, if there are two sites, how does it make the difference?
Yes. Now, Your Honor, may kindly see what is the suit schedule property. I produce a photograph. Page number 166.
166.
There is a photograph. Next page, Your Honor will make it very clear. Site number 12 and 13 is item number 10, 2 vacant sites. Here, towards the eastern side, Your Honor will find the building, almost 15 years old, multi-story building.
No, let's go to the plaint again, page number. Where is the schedule in the plaint?
Schedule,
Yes.
page number 31. Page number 31.
No, you might have mentioned what the document contains as on that day, not on today.
No, Your Honor, Your Honor may kindly see.
No, as on that day,
Which-
what the document contains, the boundaries.
Boundaries
No,
also.
Your Honor, this
different.
building doesn't,
Boundary is also different. His property is my property, carved out on survey number 78. There is
No,
no
it's not
reference.
that. Now in the plaint, what is that you have said? Let's look at it.
Oh.
In his plaint.
Please,
All that piece and parcel of the immobile property site, world number 12, so and so. Total 1200 square feet situated at 8th acre, so and so. East by site number 13, west by site number 11, north by, so what is wrong with this and this?
Your Honor, the kata is of 2020.
Hmm?
This kata is of 2020.
What it says?
Site number 12 and 13, vacant land,
That is vacant site only.
land.
Where is there? It's only one site.
Only
That's
one
what-
site.
That's vacant.
No, you,
Milad, that is Milad 16 to 40, that is Milad. That is in respect of
No,
survey
you-
number 70. Milad, kindly see the schedule. His schedule is different. My schedule is
Not-
different.
I'm looking at only your schedule. Do you deny that this is not the Sul schedule property?
But this is Milad, but Milad, Milad,
According to you, whatever
that
that
is
has been
13 to 40.
latest till 2020, you have filed the kata. As per that, you have been paying the taxes for 2 vacant sites.
Please, Milad.
Where is the vacant site? One more.
and if Your Honor,
And all those buildings appears to be old buildings.
old building, 15 years old building.
Milad, that is Milad, Milad, there is some discrepancy in the kata, Milad. That is 13 to 40. Maybe Milad, it was overwritten that in the kata, but my submission.
No. That, please on that, you get the specific instructions and make
Please.
specific submission. Or else we may have to vacate the intermodal.
No, Your Honor, there is an order of status quo passed by this honorable.
In this
council.
case,
Yeah, it may be conditioned.
Status quo,
You-
status
you-
quo.
intermodal earlier granted is extended.
No, Your Honor, can
In
you
the
see
next
this
state of
at the
hearing,
stage of
Post
defendant
this
evidence.
matter on October 15. Yes,
Please.
next.
28. Cell number 28.
Yes.
Here for respondent number
This is for defendant's appeal, my lord,
Arising out of the same suit.
arising out of this. Both the matters are arising out of the same.
You are the,
I'm the defendant in the.
what is the suit for?
The suit is for declaration and injunction.
Permitted to file my statement of
Uh.
objections to their application. I may be permitted to file my statement.
Yes,
Please.
pass on. Yes.
The suit is for declaration and injunction.
Mm.
But I have produced the plaint at stage 34 of the comparison. Lord, the facts of the case in brief for this, my lord.
What is the IA?
Lord, IA, one is filed by the plaintiff, my lord, under Order 39 Rules 1 and 2. Seeking an order of temporary injunction restraining the defendant, that is me.
Injunction, interim
from
injunction,
Alienating
the property.
the suitable property.
Mm.
But another application is filed by,
Which is the appeal arising out of injunction?
please, madam,
Which is the appeal arising out of this not to alienate?
6174, first one,
One?
74.
Ah.
Here, madam, in this,
This is IA number 1.
IA number 1, madam.
Next IA number 2.
IA number 2 is filed under Order 39 Rule 1A.
Mm.
IA number 3 is filed under Order 39 Rule 4. So,
Not the 4. What is the second relief they sought?
IA number 2.
What is
In
that?
that, my lord, the defendant has filed an application seeking an interim order of temporary injunction,
It is-
restraining the plaintiff from
Interfering.
interfering with the property. in
That's IA number, that is MFA number 6165.
6175. But
Yes.
facts of this case are this, my lord.
So court dismissed your application, allowed his application.
Court dismissed my application, allowed his application. that
Absolute, it was made absolute.
Made absolute, restraining me from
Alienating the
suit
property. Please
But
come.
your
to
lordship, my kindly say facts of this case or this, my lord. But one, Krishnamurti was the owner of the land to an extent
the-
of,
First tell the court, what is the case of the plaintiff?
please, my lord, that.
Huh.
But the case of the plaintiff is that, my lord, they are the owners of the suit shed, item number 1 of the suit shed property, 10 acres of land in survey number 348/3 to an extent of 10 acres. Their claim is that, my lord, they have succeeded with this property through one Krishnamurti, who happened to be the husband of the first plaintiff and father of the other plaintiff. My lord, they said, while filing the suit, they have suppressed all the sale transactions taken place. Lord, your lordship, my kindly facts of this case or this, my lord. Lord, the one, admittedly, one
No,
Krishnamurti.
so initially, when they filed the suit, they have not sought for any relief of cancellation,
No,
simple declaration.
simple declaration.
According to you, who is denying their title?
Lord, the plaintiffs are denying the title now.
Not the plaintiffs.
Allah, I am denying the title and they have filed the suit against me. Lord, your lordship, my kindly say facts of this case or this, my lord. Lord, the one Krishnamurti is the owner of the land to an extent of 14 acres, 29 guntas in survey number 348/2. Your lordship, may kindly peruse the synopsis, my lord. I'm making submissions on the basis of the synopsis. Krishnamurti was the owner of the property, my lord. This property was mutated in his favor, my lord, wide MR number 13/96.
What is this? What is meant by this?
Please, ma'am.
What is meant by Pauti Varasu?
By way of succession.
Hmm.
By way of succession.
It's called
Ma'am,
Anuvamsikam. Yes.
Please, ma'am. Thereafter, my lord, Krishnamurti had sold 5 acres of land in favor of one Ramkrishnappa under a registered sale deed dated 7/5/1997. 7/5/1997. And he has sold another piece of land in favor of Ramkrishnappa, my lord, under a registered sale deed dated 12/7/20. That is 2 acres. Then, my lord, another
How
3,
much he has sold? 5 + 3 + 8 + 2, 10.
10 acres,
He
yes.
sold 10. So
Yeah,
still 4 acres remains to be with him.
Remains to be with him. It is remained with them. Records are standing in their name. Then, my
4
lord,
acres, 29 guntas remains to be with them.
remains to be with them. Lord, your lordship, my kindly say, my lord, there are several sale transactions have been taken place after the sale by Krishnamurti. In the year 2008, my lord, one Raghunandan who had purchased the property from K.C. Krishnappa had sold in favor of Raghunandan. Raghunandan and Gurlingappa have sold this property in the year 2015, my lord, under a registered sale deed dated 2/2/2015. There are several transactions have been taken place, my lord.
So now, according to them, they are the owner. What is, come to the plaint once?
Plaint, my lord. Plaint is at page 34, my lord. Para 4, my lord.
Come to the schedule of the
35.
property.
Please, my lord. 37, my lord, page 37. So
The entire 14 acres they are seeking declaration.
they are seeking entire 14 acres.
14 acres, 29 guntas, they are seeking
29
declaration.
guntas. Property which is in my occupation is coded as 348/3, 10 acres. After I purchasing this property, code was conducted. It is 348,
Occupation of 10 acres of land.
10 acres of land. Not only with respect to that, I have.
No, after you file the written statement, did they sought for any amendment in the plaint?
They have filed, it is pending.
That is pending for consideration.
They have filed, my lord, it is pending for consideration.
No, at this point of time, how are you entitled for, how the court has not considered all that?
My lord, the trial court, since they have insisted for disposal of these 2 applications, earlier, my lord, what had happened after appearing the defendants, they filed an application against me, seeking an interim order to restrain me from interfering with their possession. They are keen to dispose of that application. Therefore, my lord, the trial court passed orders on these 2.
No, initially ad interim injunction is granted, restraining them from alienating the property in respect of entire 14 acres of
14
land.
acres.
14 acres, 49 guntas, 39 guntas or 49? 29 guntas of land. No, they have placed by filing a written statement, they have placed before the court that 10 acres of land already Krishnamurti had sold long back and several people it is sold and finally is in.
Correct.
Then in that case, for entire extent of land, how can there be an order of not to alienate? Number one. Number two, and when they could show that their 10 acres is already sold by Krishnamurti, why are they not entitled for injunction as far as this 10 acres are concerned?
So, my lord, now the court passed an order restraining them from alienating the suit scheduled property, whatever.
That
it
is
may be
14 acres, 29 guntas.
My lord, to that effect, order may be modified.
That will be modified, number one.
Till
Next, injunction is concerned,
Please.
you cannot interfere with 10 acres which
Lord,
is
as far-
purchased by them.
No, my lord, as far as that application is, my lord, there is an order. There is the order of this honorable court, full bench. A defendant cannot maintain an application in the suit filed by the plaintiff to restrain him from interfering with the possession of the suit scheduled property. That is a full bench judgment, my lord, may be permitted.
What is the judgment of the Supreme Court in this regard?
Well, full bench judgment is.
No, full bench. What
But
is
the
that?
same judgment was followed by the honorable court in the recent judgment passed on 2022, my lord. I have produced that judgment also, both the decisions. Because order 13, they are entitled for an order under order 39 rule 1A, not under order 39 rule C. They are seeking to restrain the plaintiff from interfering with their position. That is not permitted.
Here it is a case.
Yes.
Now, by filing the necessary material, they could show that they are in occupation of the property in respect of 10 acres of land, which you sought is 14 acres, 29 guntas, which is sold by your grandfather or your father.
That sale deed is also challenged. My
No,
lord-
you
my
might
lord,
have
there-
challenged, but sale
there-
deed,
my lord,
no.
my lord, for a
Sale deed is
moment,
a public document.
my lord, for a moment, can
But first of all, section 3 of the Transfer of Properties Act, that is deemed to have been in your constructive notice.
Your lordship, for a moment, kindly see, they are claiming that the sale deed that was executed my father in the year 1997. My lord, as on the date, the father of Krishnamurti, he was alive. Actually, this property was belonged to one Balamma. He had only one son by name Guddappa. My lord, I have produced the death certificate of Guddappa. He died in the year 2028. Now, the claim of the appellants that the first sale deed was executed by Krishnamurti in the year 1997. My lord, during the lifetime of the father, my lord, son, he is not entitled for any share or a title to execute any sale deeds. Though
Why did you not question? All must have been
by
reflecting.
way of amendment, I have filed.
No. First of all, now when this, now once there is a registered sale deed,
Please.
it will be reflected in the AC.
My lord,
And all
for a
those
moment,
sale deeds
kindly-
are of 80s and
Your lordship,
90s.
lordship,
You filed a suit in 2020, which year is the suit?
2023.
20.
My lord, one more point.
No, what is your submission with regard to the full bench judgment and that you cannot seek an injunction under 39?
My lord,
Rule
there is a judgment to that effect, my lord. I am not going to dispute that. But for this reason, I have challenged that order, my lord. But taking undue under what circumstances, the circumstances under which I have filed that application is, my lord. Taking undue advantage of this order, my lord, they went to the police station saying that we are in possession of this property by misrepresentation.
No.
By,
And once you accept the fact that you cannot maintain an application
please,
in a suit, in a plaintiff suit,
please.
and then whatever should follow the consequence.
My lord, my submission regarding that is, my lord, I may be put in liberty to file a fresh
Appropriate
application before the appropriate suit, my lord, and the trial court may be directed to dispose of the same without being influenced by the order passed on IA number 2 in the present application. That can be done.
Please come.
In the second matter. In the second matter.
Yes, I understand.
In the first matter is concerned, my lord, interim order.
Interim order that not to alienate, because he cannot alienate your property.
For 10 acres to that effect, my lord, the order may be modified.
No, who will alienate?
Because now the.
No, he cannot alienate some property which is not in his position.
My lord.
No, he is, according to him, he is owner of 10 acres of land. You are
No, I am
claiming-
not disputing, I'm not admitting their ownership over the property nor their possession of the property. My lord,
And you will say that as far as 10 acres of land, which the petitioner has, the appellant defendant had purchased, in respect of that, the order is modified, only restraining it to 4 acres, 29 guntas.
Please.
Restraining them from alienating 10 acres, madam.
Huh?
Because sale deed is for 10 acres of land. Now the entire, out of 14 acres, my lord,
Those are
10
all
acres is-
purchased long back. What were you
Your-
doing from 84?
my lord,
Now with a plaintiff who comes to the court with such an inordinate delay, now if anything is hit by lis pendency, it will be his will. These are not the cases where the courts will grant orders of this nature. The agreed with the order. Huh? Huh. Yes, what do you say?
Please, ma'am.
For the respondents, he has filed the caveat only in respect of R4.
Against R4 only interim order is operating.
No, then you have to say that others are not necessary for this. Give a memo, write a memo and give that for the purpose of this application,
Please,
the others are not necessary, so a notice to them may be dispensed. with.
please.
We'll pass an order, write a
Please,
memo and give.
please.
Agreed with the orders passed in I number 1 and I number 3.
I number 2 minutes.
IA number
two, ma'am.
So
2.
from the order it appears I number 3,
In which
Well,
part?
Yeah, my lord, there are two.
page number 24.
My lord, in 6174,
No, I'm looking at 6174,
6174 is my lord 2.
but it's not there. Come to the order.
I number 1.
Page number 22 is the order, I think.
Page number,
22, 622.
please.
I number 1.
This is 1 and 3. One is 39 rule.
It's not 2, I'm saying that's what.
Please, my lord. One.
Agreed with orders passed in I number 1 and I number 3 by so and so. In OS number 233 of 2023 dated 3rd August 2024, the defendant is before this court. The appellant herein had initially filed a suit seeking declaration and injunction. It is his case that the plaintiffs have succeeded the property and the property belongs to the husband of the first plaintiff and the father of the second plaintiff.
224, plaintiff number 224.
Plaintiff number?
224.
Husband of the first plaintiff and father of the plaintiff's number 224. And according to them, the said Krishnamurti has acquired the said property
By way of inheritance.
by way of inheritance, and being the wife and children of Krishnamurti, they have succeeded to the property, and the defendants are interfering with their peaceful possession and enjoyment of the property and also denying the title of the plaintiff. As such, they have come before the court seeking the relief. They filed I number 1, restraining the defendants from alienating the property. The said IA, the court had passed an interim injunction. Thereafter, the defendants have entered into appearance and they filed their written statement. And they have filed an application to vacate the same. And also, that is IA number 3.
For vacating.
Vacating is I number, they filed an application, I number 3. And also, they filed an application. What is that IA then, when it is IA number 1?
IA number 2 is,
Is his injunction?
I have filed an application.
That is the subject
Then they
matter
filed
in
an application.
617.
They filed an application to vacate the injunction. Then IA number 2 is filed to restrain the defendants from restrain the plaintiff from interfering with the defendant's peaceful possession and enjoyment of the property. It is a case of the defendants that the suit, in fact, Krishnamurti had sold the property. That Krishnamurti is the owner of the property of an extent of 14 acres, 29 guntas. On 7/5/1997, he had sold 5 acres of land under a registered sale deed in favor of 1 K.M. Ramakrishnappa. On 18/10/1997, he had sold another 3 acres of land under a registered sale deed in favor of 1 Gurlingappa. On 12/7/2000, he had sold another 2 acres of land in favor of 1 K.M. Ramakrishnappa. Thereafter, what is the name of the defendant, the appellant?
KN Madhu, my lord. And
K.M.
KN Madhu.
Thereafter, on 13th, in the year 2004 and 2008, certain transactions have taken place. And finally, the defendants have purchased the property in the year
2015. To 2015, my lord. 2015.
They purchased the property in the year 2015. And according to them,
Krishnamurthy died in the year 2021, my lord.
according to them, they have been in possession of the property ever since. And defendant was never in possession of the property when Krishna when Krishnamurthy had sold 10 acres of land, showing the entire property, they have filed the suit for declaration. It is their case that under the guise of the said order, in fact, the plaintiff is interfering with their position and hence they have filed IA number 2, seeking injunction. The trial court, by order impugned, had made the had made the injunction restraining the defendants from alienating the property absolute and dismissed IA number 2 filed by the defendants. Aggrieved thereby, 2 appeals are filed. MFA number 6174 arises out of the IA number 1 and MFA number 6175 arises out of IA number 2. The MMO is filed before this court stating that the relief that they are seeking is only against R4 and R4 is represented by a caveat
R1 to 4.
R1 to 4.
1 to 4.
And the R1 to 4 are represented by the caveator. And as far as the other respondents are concerned, they are not seeking any relief against them. Hence, a notice to them may be dispensed with. Accordingly, this court had dispensed with service of notice on those respondents at the risk of appellant. Now, this should be an order on the memo also. The trial court, by order impugned, had observed that both the parties are claiming right over the property, and according to the plaintiff, they are claiming right based on inheritance. In support of the same, they placed Kata acceptance document in the name of the husband of the plaintiff number 1 from the alleged owner Baramma. Further, they are also placing reliance upon the manual RTC extract for the year 1998-99, coupled with tax paid receipts and revenue entries. According to the defendant number 1, they are claiming the right based upon the registered sale deed dated 2/2015. Even the defendant number 1 also produced the sale deed passing title in favor of his vendor as per the sale deed dated 8/3/2012, coupled with other relevant documents like sale deed, mutation, registration, extract. The court has observed that when both plaintiff and defendants are claiming right and title to the property, the only remedy available to both the parties is to face the trial as it's a matter of evidence and requires investigation by this court. And the court felt that the plaintiff had made out a prima facie case. And at this stage, a mini trial cannot be conducted as there is a strong dispute with respect to title of both the parties. And as it's a suit for declaration injunction, the suit scheduled property has to be necessarily preserved. As the plaintiff had made out a prima facie case and balance of convenience, the court had allowed the application, had made the order passed in IA number 1 as absolute and dismissed IA number 3 filed by the defendants. And as far as IA number 2 is concerned, what is the finding on that? Why it is, sir?
IA number 2, my lord.
Your injunction.
Regarding that, my lord, the trial court has recorded a finding that in the RTC column, crops are not mentioned.
The court had not granted injunction as far as IA number 2 is concerned, as filed by the defendant. The court observed that they could not make out case to show that they are in possession of the property. Take that. Take that. They are in possession of the property. I have already told her, children. Memo is taken on record. Agreed thereby, by filing these two appeals, the defendant is before this court. Then counsel appearing for the defendant has drawn the attention of the court to different sales that are executed by Krishnamurthy. According to him, suppressing all these facts, they filed this writ petition and they have filed the suit. And further, after the written statement is filed, they filed a petition seeking amendment of the plaint, and the same is pending consideration before the court. It is, and counsel submits that the court had not considered the evidence available on record, and the fact that when the rights from the year 1997, when several sale deeds are filed, are executed in the year 2023, when he comes up before the court suppressing all the facts, the court ought not to have granted injunction to the plaintiff who has come before the court with suppression of the material facts. It is submitted that the court had failed to consider the application in its proper perspective. Next para. When counsel appearing for the plaintiff caveator submits that in a suit of the plaintiff, the defendant cannot seek injunction. He had relied on a full bench judgment of this court arising out of in a case of in between Shanta Shakuntalamma and others versus Srimati Kantamma and others, reported in ILR 2014 Karnataka 6025. It is submitted that the court was right in not granting injunction. Was right in not granting injunction in a suit filed by the respondents herein. He submits that the Krishnamurthy has no right to execute the sale deed, and as such they have questioned the same, that they are not binding on them. All these things have to be decided by the court by way of a full-fledged track. And at this point of time, if the injunction is not granted, restraining them from alienating the property and the properties are alienated unnecessarily, the third-party rights would be created. And the court had rightly observed that the sued property has to be preserved. He submits that the no grounds are made out for seeking interference with the well-considered order passed with the trial court. Next para. Having heard the counsels on either side, there is the material on record. The plaintiff had filed a suit for declaration and injunction in respect of 14 acres, 29 guntas. According to the plaintiffs, they have succeeded the property from one Krishnamurthy, who is none other than the husband of the first plaintiff and father of defendants number 225. Thereafter, initially court had granted injunction restraining the defendants from alienating the property. The plaintiff had the defendant has filed his written statement, has categorically stated that what are all the documents right from 1997 that were executed by Krishnamurthy in respect of 10 acres of land. Thereafter, the plaintiff had sought for amendment of the plaint, which is yet to be decided. So, at present, what is there before the court is the transactions, the sale deeds that are in favor of the defendants. Finally, the appellant before this court who had purchased the property, who is purchased the entire 10 acres of land. Until unless the release
Acres of land out of 14 acres.
out in 14 acres, 14 acres, 29 guntas. Unless now whether the amendment petition will be allowed by the court or not, unless and until an order is passed. Now, on the face of it, there is a sale transaction in respect of 10 acres of land. And all those aspects. Yes, Anita? What do you want? Later after the case, you can ask. All these aspects have to be decided by the what is the connection with unless and until the said amendment is allowed at this point of time, the defendants could prove that, could place before the court that the plaintiff had not come before the court with clean hands, as when they're claiming ownership in respect of 14 acres and all, the EC will reflect all these aspects. Why they have not stated all that before the court has to be explained by them in an appropriate application. In that view of the matter, this court is of the view that the order that is passed by the court in IA number 1, restraining the defendants from alienating the property has to be confined to 4 acres 29 guntas, but not in respect of the entire extent of further there are no sale deeds.
No, my prayer is, my lord, they have purchased 10 acres
That is
of
not
land.
your that is not your prayer. You have never said so. In the plaint. In the plaint, you have not said so. No, by amendment, you have taken such a plea. Whether, which is barred by limitation, such an amendment can be ordered or not, all to be decided by the court. So as of now, you have not, there are no bona fides in your application at all. For that matter, the entire now, I think there is no question of modification. That injunction can't be granted. Because you are not.
I may be permitted to fresh application, ma'am, to that effect.
As such, this court finds no reason and no such order can be granted. Hence, IA number 1, filed by the plaintiff seeking injunction restraining the defendants from alienating the property is dismissed. And the application filed by the petitioners, that is IA number 3, is allowed. Then coming to the application, that's IA number 2, that's filed by the defendant seeking injunction as considering the judgment of the full bench referred to Supra in Shakuntalama's case. So the defendant is liberty to move an appropriate application and not the.
No, by filing a separate
Anita,
suit, my lord.
Separate suit there.
Anita, what's going on continuously? Somebody is talking. Without going into the application and the court, without notwithstanding the order that is already passed in IA number 2, shall independently decide the application within a time-bound manner, as expeditiously as possible.
File a separate suit and file such application. Liberty to file a separate suit in that.
Why will this court will, in this suit, why will this court will grant in an no. We will not
As
grant.
per the judgment, my lord, now your lordship referred, otherwise defendant can file a suit, separate suit
Then
and.
tell the court and seek a relief.
But as far as.
Whatever is the appropriate remedy available to the defendant, defendant is at liberty to pursue the same.
Please.
My lord, as far as the
If the amendment is allowed, the appellant is at, the plaintiff is at liberty to move an appropriate application, if whatever the appellant decides to see. Yes,
Much.
both appeals are disposed of.
Much.
Yes,
Cell number 36.
30?
Six.
Oh,
Yes, respondent.
yes.
On the last occasion, my lord, your lordship had asked me to ascertain medical and educational expenses of the child. Lord, I'm given to understand that as on the year 2023-24, my lord, the child was studying in a Vidgya school where the educational expenses amounted to 4.5 lakhs. And his medical expenses amounted to about 40,000 per month because of his hemophilic condition.
Per month, 40,000.
40,000 a
On
month.
the last occasion, you were submitting that in all the hospitals, you will get the free treatment for that.
No, my lord, that is only in the government hospital. There is no time. So if in his case, my lord, there's an internal bleeding that occurs, immediately he has to be rushed to a hospital and he needs medical care. He can choose at that point in time which government hospital is available if the medicine is available in that government hospital for his care. Now, my lord, today, if your lordship had.
What is his income, father's income?
I do not know. He will have to say.
So what you have to,
He had, on the
basing
last
that.
occasion, he had
No,
submitted
no,
his
no,
2 lakhs
basing
per
on that,
month.
for example, if the father's income is, for example, it's 60,000.
Correct.
So
No, he had
necessarily,
submitted
no,
2
no.
lakhs per month.
Necessarily, you have to go to a government hospital.
No, agreed.
So that's what is now relevant.
No, Milord, at the end of the day, the order in the family court is 50,000 per month, which was passed in the year 2020,
50,000
50,000 a month.
towards educational and medical,
both together.
medical.
Yes.
So you are saying that how now?
I have not challenged that order. He has challenged that order seeking for a reduction.
No, he's not paying the educational
He's
expenses.
not paid either of them till this court took cognizance of the matter. On 19/3/2024, my lord, this honorable court passed an order asking him to deposit 25 lakhs to show his bona fides and asked me to submit the terms of settlement, my lord, which I did. But 25 lakhs was not deposited by 1/4/2024 as directed by this honorable. Subsequently, when the matter was posted before the family court, when I moved for attachment of movables there, then he comes, an attachment was passed, then he comes in order to release the attachment, pays 15 lakhs, not even the 25 lakhs as ordered. Thereafter, my lord, the same matter
Who is
comes up
seeking this
again.
modification of the order?
I had, not,
He has sought.
not, through my bona fide, not 17 lakhs has now been paid. I had said, not kindly permit me with the, because your lordship, may kindly see the order not passed on 26/3/2024. Okay, this is the case. The mother will not enters into a compromise with me before the family
No,
court.
it's not 26/3.
I'm sorry, Lord, it's dated.
It's 93.
19.
Hmm.
19.
Hmm.
Kindly see not para 8 and 9. Para 7 is 25 lakhs, your lordship directed through my bona fides to pay 25 lakhs. Then when the parties want to amicably settle it, when the husband has said it before the court, he's ready to take the responsibilities of both educational and medical needs of the child. Respondent wife should come up with her requirement about what are the terms of settlement.
Yes.
In view of the same, respondent wife shall come up with memo or with an affidavit before the court, what are the terms of compromise. The terms of compromise that the respondent came up with was, we have 2 apartments. She's staying in one, I'm staying in one. Both apartments must go to her, or one to her and one to the child. I must pay 50,000 rupees per month towards my son's maintenance, and I must pay the educational expenses and take care of his medical needs.
My lord, on the
Therefore,
last.
your lordship, can I?
Yes.
Therefore, your lordship on the last occasion said this proposal does not seem to be reasonable. Please give us a list of expenses that you have. That list, my lord, I have not seen to date.
No, my
The
lord.
court is not, your lordship's order on the last date says, respondent shall come up with details, figures of medical. and
Giving the
educational
figures, my
expenses.
lord. I am. giving
Orally.
them. No, very well. My lord, my simple submission is this. My lord. Now, this, your lordship had suggested that the amount of 50,000 per month till he attains 25 is a reasonable figure. That is what your lordship had said. He had agreed also.
I'm sorry.
That is a condition in the memo settlement, which your lordship had said was reasonable, and he accepted
I'm
last.
sorry.
No, there the issue that day was about the
No,
apartments.
if the other.
Apartment.
No, if
One
Apart from the
apartment,
apartment,
one
my lord.
apartment shall be, it will be with you, and the other apartment
Which is
she'll
fine.
have as a.
We keep that aside.
No, if
We are
I-
not getting,
if I
I'm not
had-
even getting into that.
If I had at least 50,000 rupees per month, I will withdraw my writ petition. There's nothing left. The challenge is to 50,000 rupees per month. Last occasion, I submitted this. No, my son.
No, that is.
My son
no,
turns 18 next year.
That
If
is
I withdraw
only
the
with
petition
regard
now-
to this interlocutory application. Now, what was suggested is for about a final, full and final settlement.
True,
Uh,
true.
yes.
Your lordships felt that the proposal given by the other side was not proper, and therefore they were asked to give.
No, why the court felt was when she wanted both the apartments.
And also the
And
50,000
also 50,000.
and 50,000 and medical
So now
education
the,
expenses.
now the 50,
If the
now the
apartment is-
apartment issue,
yes.
let's keep it aside.
Yes.
50,000 medical and educational expenses
Both
also to be
together.
borne by the father.
But the court has not given that.
Court has granted 50,000 towards educational and medical. My lord.
And
But
maintenance.
coupled with that, it's only 50. Now, when the proposal you are giving,
My lord.
you cannot give more
No,
than
since
what,
No, my lord, since it was one-time settlement, my lord, I suggested that
the
it
boy is 18 years old, 17 years.
70, now he's doing his 12th grade. It's not like when he's 18, he can start fending for himself, my lord.
No, not
Why?
that. He'll give,
And
but,
secondly,
but
my lord,
not,
his medical condition is such that he has to, at least 4-5 times a month, he has to go to the hospital. my
I'm
lord,
sorry.
Because of his.
No, these are things. No, let them place it on record. But let us now play. Let us
why
play
don't-
it.
Pay
no,
what
we'll
is
see,
due
one
at
thing- no,
least
no,
till
no.
date, my lord.
Why don't we see his medical record? Why don't
I
you
will,
place
I'll
it
place
for the
it, my
court?
lord. But meanwhile, let him pay at least what is due, my lord. The amount due is 39 lakhs till date.
I'm sorry, man. 17 lakhs is already paid.
So the balance has to be paid, my lord. Your lordship had directed him to pay 25 to show his bona fides. At least that he can pay, no, my lord.
Therefore, I filed the
That he's not willing to pay. He's asking for reduction even in that.
What is your salary?
No, we have not filed, both of them have not filed their
Let
absolute liabilities. Both have not filed,
Very well.
because the order was passed in 2020 during. the
Prior
times.
to the, prior to.
Prior to the
Then we'll
judgment.
do one thing, then you continue to pay 25,000 per month, if not 50, then let the court decide based on the statement
Court
of.
has already decided, my lord.
This
till-
is on
till then,
SSN level,
till then.
please. We'll
No,
set
they-
aside that order till it is decided, he'll pay 25,000.
But
At 25,000, let at 25,000, arrears also you pay.
25,000, my
Well, not
lord,
the-
is too less because the
No, no.
child's.
No, we are
No,
trying
the
to settle
court
entire
has to
dispute.
decide, the court
If
has
he
to
wants to
decide.
settle the entire dispute, the terms are there. If he's willing to settle, I'm willing to settle. But let.
If that's happening, why both of you are before the court?
No, not those terms.
No, as I said, apartments can be
Then
set aside.
we'll refer it to mediation.
Very well, but I will pay 25. Lord, I am not shying away from maintaining my son. All I'm saying is, well, there should be some reason that the court will not, the court does not say the educational expense is so much, his monthly maintenance requirement is so much. Court says 50,000 rupees a month you pay. So ad hoc figure with no justification, my lord, with absolutely nothing. If the mother can
No,
give
if you're
even now,
saying, if you're saying 25,000, how much the arrears will come to at 25,000? What are the arrears at according to you
16
at
lakhs.
50,000?
it will be 16
Not
lakhs.
39.
33 lakhs, it will be 16. I've already paid 17 lakhs.
No, no, it's 33 as on June.
Very well, for another 2 months. So-
Then we'll say like that. Then please come,
wait,
the parties are directed to appear before the mediation center on 15th of October at 3 p.m. The judicial is directed to communicate the same to the mediation center. As for the orders, though earlier this court has directed to deposit 25,000, the petitioner has deposited 17,000.
Lakhs.
17 lakhs. Both the parties submit that. They have not filed the statement of assets and liabilities before the trial court. And this was during the COVID period. Considering the same, this court deems it appropriate to direct the husband to pay 25,000 pending consideration of this application. As he has already deposited 17,000. 17 lakhs. The 17 lakhs, the wife is you have withdrawn it. If the wife is
He paid it directly to me.
he has already paid 17 lakhs at 25,000 per month. There are any dues as on today, apart from that 17,000, he shall pay, and he shall continue to pay 25,000 by 5th of every succeeding month.
Yes.
Once it comes back from mediation, we will see.
Obliged.
Will it, no, my lord, mediation or is it going to be remanded?
No, first mediation, then we will remand,
Right.
Obliged.
if it's not happening.
Very. Till number 38. Hemalata Mahishi. For the petition.
This case, Lordship may kindly remember, it is a custody matter on 6.
The lordships had examined in the chamber, my lords, the child.
I
The
remember.
lordships
I
had
remember.
passed an order on 5/8/2025. Lordships may kindly.
5/8?
2024.
5 or 6.
Not
The
5/8, it
lordships
is on
permitted-
37,
Lordships permitted lords on 3/9.
5/2024 and 37/2024.
No, your Lordship.
It
properly-
is
No,
not-
5/8 there is, as per the
8
order.
lords,
Counsel and the
lordships
parties are
lords
present
direct-
before this court had interacted with the father. It appears that from the conversation, the child has some reservations talked to the respondent with all his previous experience, considering that the child is studying in it. This court is not inclined to pass any order directing him to meet the respondent. However, it is stated that the child has no issues to, did he meet the grandparents?
He has met the grandfather, my lords. He is comfortable talking about the grandfather is also present. Lords,
Ah.
the
But
only issue
only-
now is, my lords, they have sent it on 4 occasions. Then, my lords, they have stopped for the last 2 occasions, 2 Sundays. The child is not sent to meet the grandfather.
I will submit. That's what I wanted to submit.
Yes.
The first, after this order is passed, child went on Sundays, 3 Sundays. But Sundays, he used to be in the house, he used to interfere. What happened was, the grandfather will be interested in the child only for 10 minutes. Thereafter, he goes out and sits outside and all that. And the child starts playing with his old friends there around and spends that time and comes back. But what happened was, he was interfering and he scolded the child, why did you tell against me before the judge? That's what. And thereafter, after he went.
After interacting with your client.
Yeah,
Lords,
he
I would
started-
say this, I will.
No, after interacting with your client, without the court being there, I will take what her statement, we can take her statement on the face.
That's why.
It's my.
It was like when, even after the interaction, during the interaction and after the interaction also, in spite of the court orders, he was literally.
Lords, may I make this, Lords? Your Lordships may make.
For his age,
Your
he
Lordships
should
may
have
clarify that. Your
respect,
Lordships, Lords, my instructions are not, none of these are my. Your Lordships may clarify when the child comes, let the father be not there.
No, not
Yes.
on Sunday.
Let them
but
send.
just-
Let them
just
send. Lords,
make-
let them make all. not
What is
make
she
all
saying?
this.
Let's listen to her.
But after that, one Sunday, 3 Sundays he attended. One Sunday, he was not well, he did not go. But thereafter, he refused to go on Sundays because of this interfering. Then he is going on other days when he is not there. Once in a week, he is regularly going.
So what we'll do is now, we'll make it sure that the father is not there. He shouldn't be there, number one. And apart from Sunday, which day he wants to go?
Any,
Because grandfather is
he
always at
went
home.
on 6th, 12th,
No,
18th.
no, you please tell it. It should be by way of an order.
Lords, the child is being used as a tool in this case.
Huh?
Child is being used as a tool, my lords.
No,
I would make this submission, my lords. Lords, let this order, lords, to meet the grandfather, let it be confirmed. Let the trial be commenced and let the matter be disposed within 6 months, my lords. Let whatever happens in the matter, let us take some
MC is of
finality in this, my lords.
JWC is of which year?
Lords, it's not GNWC, it is divorce petition where we have filed an interim
Which year
application.
is that?
It's 23, my lords.
23, we can't pass any orders
They are
directly.
using this as a tool, my lords.
no.
And
No.
every time.
No,
lords,
we'll see what we'll do is, now this order which is made, which is passed on 5/8/2024. We'll make it as a final order.
Your lordships may
But
talk to
not-
the grandfather, lords,
not-
at least to the grandfather.
Sundays.
No,
When
which
they
day?
are working day, he will go in the evening between the same time, same order, but only some other working day. After
Wednesday? On a Wednesday?
Very well, no problem.
Yes. And we'll dispose of this application.
Your lordship may dispose, but let there be direction to the trial court, lords, because
No,
You
it is only
can't,
2 hours,
because
your lordship.
please
In fact, the trial
understand,
court.
MC of 20 to 23, this court cannot direct the trial court to dispose of, because only till now 2019, so whenever any mandamus is also asked, this court is directing only in respect of 2019, not later than that. Because there are so many other matters, we can't pick
Well,
and
lords,
choose.
apart from that, this matter is not pending before the family court. It is before the civil court, lords.
whatever may be.
A rural
Why is-
court where there are not much of a
why
matter.
is so
I
much
understand the
interest in
burden.
Getting the divorce so early. She's
I am-
not
I am-
interested. She is ready to go. Because of the son, she is not able to go in spite of his violence and all that.
No, that's not the case.
So
What
let
she
it
told
go.
us, she's not interested.
Yeah, no.
No, it is not, please understand. Any of the parties, like these proceedings are not for settling the scores.
Yes.
People come to court for a relief. Either of the parties should look at it like that. It is not that I will not grant divorce and forever it will be pending.
Let it go. On the merit, let the court decide the matter on its merit.
Why is it
I
pending
am
in the
not
civil court?
enjoying the litigation, my lords. End of the day, I want to see some.
Which court this is
It's a
pending?
rural court, my lords, because the parties were residing in a principal senior civil judge,
Ah,
rural court,
no.
Bangalore. my lords. It's not in
This,
the family.
the registered judicial is directed to find out what are the cases pending before which court is this?
Senior Civil Judge, Bangalore Rural District, notes MC number 604 of 23.
Senior
Rural court.
civil, not necessary. Bangalore rural, how many matters will be pending?
Not much of them are there. lords.
Ah,
I think my lords, my
The
friend wants to
MC
keep
is
the
pending
litigation
before
alive.
the family court, Bangalore rural. For the year 2019, 20, 21 and 22, what are the matters pending before the court? The registrar judicial shall place the same before the court. And
This
find out
arrangement
and
may
inform the court. Close this matter on Thursday. We'll pass orders on that day.
This arrangement of
This
Thursday, my lords.
On Wednesday, this order may be changed to Wednesday.
Ah,
instead-
no, it is coming up on Thursday, this Wednesday. Today is to Monday.
Monday.
But it may be,
No report. Online they can have, no, just not a report, just an information.
but your lordship may kindly post it on 1st October. Because this week, we are having the conference.
My lords have expressed,
Yeah.
lords,
We are-
lords, we have understood, we have come to some conclusion now. Your lordships said that this
There is
arrangement will
nothing on that day,
continue. There is
what the
nothing.
court will do is, even if you're
Lords, no
not there.
adverse orders is going to be passed against them.
Please wait. On that day, what the court is going to do is, once a registrar says that there is no much pendency, then we will pass a direction to expeditiously dispose it of.
But
If the cases are pending, no such order will be passed. This arrangement of Wednesday will be made as a final order.
no problem.
So nothing, no more, nothing, no arguments on the day.
Wednesday, the change.
Same, that Wednesday order will be
Let it
final.
not be posted during this week, that's my.
First, how many matters this court can hear?
No.
And I'm
Hardly
telling you,
takes
no,
No,
5
this
minutes,
week
my lords,
I'm
to
really
take.
very busy with our,
then I can't help it. I'll adjourn it, pose this matter after vacation. No, that order also remove that the extrajudicial and all. Pose this matter after vacation. The order earlier passed by this court is modified, and the boy shall meet the grandfather on Wednesday, on every Wednesday between 5 to 7.
5 to 7.
Between 5 to 7, and while the boy is exercising the visitation, father shall not be present.
Otherwise, your lordship wanted to hear it on this Wednesday.
No, will not hear any matter because court has lot of work. What the advocates are not understanding is, in spite of busy work, court is trying to accommodate, and you are not understanding. Yes,
Only
next matter.
interested to see that some finalities attend in this, my lords. Every day
What to
attending.
do? Why when the advocates are not cooperating, what the court can do? Yes, next.
Till number 42,
Obliged.
Shivraj Patil, for the appellant, Ajay Prabhu.
Lordship, the court below dismissed the miscellaneous petition filed by me under order 9/13.
We'll have it tomorrow.
Yes,
No
ma'am.
time, no, it's already
Yes,
fine.
tomorrow.
Yes, 12. Tomorrow. Yes, next.
Till number 44,
Yeah, call that. Huh.
The petitioner, my lord. My lord, they've agreed, he's
Huh?
agreed to pay, he's agreed to pay 20,000.
Pay 20,000 and sign the
Yes, ma'am.
passport.
Yes, my
Yes,
lords.
ma'am.
Huh.
My lord, his only concern is that every vacation that the children are being taken on by the mother and the family, he's not being intimated. So he's ready to sign for the passport, subject to prior permission being taken by the court, my lord. If-
No, for taking the children out of country.
Yeah,
And
children
so
take-
that accordingly, the visitation has to be adjusted.
As per the discussion that took place in the chamber, my client is not okay with 20,000. She's ready to argue on this matter
Oh,
because.
it's
yeah,
an order of the court. We are not, this is not a consent order.
Yeah.
This not, I'm on the visitation, I said,
No,
not on
visitation.
20,000,
only thing is
20,000
that-
is, please understand, 20,000 is an interim arrangement this court is making till something is done. Not that, it's not on the merits of the matter. It is an interim arrangement.
Okay, my lords, that is one thing. Saturday, the kids have multiple classes. He'll have to take them to those classes also if he's exercising visitation as this honorable court is directing.
He will take,
This
he shall
Saturday.
take. Any Saturday, Sunday.
He's
This
ready.
Saturday, Sunday.
Huh.
And on Tuesday, we report on the.
Yes. What is to be done.
Sure.
This court on,
Here is a case where he is not declared his assets. He's not even given his salary.
no, please understand.
all right, ma'am. Not
We'll
merits,
go one by one after the other.
Sure.
This court, hearing the arguments of both the parties on the last occasion, had directed the parties to be present before the court. Today, this court has interacted with the parents as well as both the children. The children, it is stated with the children that the father was rude to them on 2-3 occasions. And also with regard to renewal of their passport, the father has not signed. As such, they are not able to go on vacation along with the other family members. The trial court had granted 40,000 maintenance, questioning that the father is before this court, and also the visitation that is granted by the court in the mediation center by reducing the earlier visitation that is granted. After interacting with the parties, this court is in the interest of the minors as well as both the parents. This court is passing the following order. Number 1, the father shall pay 20,000 during the pendency of this petition, 20,000 by 5th of every month. 5th of every succeeding month, and for the month of September, he shall pay the money by Thursday. 20,000 shall be paid by Thursday. Number 2, the father can exercise the visitation on Friday and Saturday between this Saturday.
Saturday.
I mean, Saturday and Sunday, only this week, that is, Saturday and Sunday between 10 to 5. He shall pick up,
Yes,
he shall pick up the child, he shall pick up the children and drop them back. And if any activities the children have to attend in that period, he shall take them to that activities. Next, the father during the course of visitation shall not be rude to them and keep the children comfortable all the time. On the next hearing, if it is brought to the notice of the court that the father was not, the children are not comfortable, basing on that, further orders needs to be passed by the court. Next, the father shall give consent for the renewal of the passport, and whenever the mother wants to take the children out of the
fresh passport.
for issuance of the passport, for the passport, the father shall give the consent. And whenever the mother wants to take the children out of the country, she should take the permission of the court. And whenever whenever the mother requests, the father shall give the consent for the passport. Pose this matter on Tuesday in the court itself, no chambers. Yeah, that is on first, not Tuesday or Tuesday. Yes, get the papers.
Much obliged.
And tell your client to be careful, and then you'll be doing it at the cost of
ಅದ್ಕೆ ನಾನ್ ತಗೊಂಡೋಗ್ತೀನಿ ಮಾಡಿರಲ್ಲ ಇದೊಂದು ಯಾವ್ದು ಕಳ್ಸೋದ ಮೇಡಮ್ ನಾಳೆ ಅದೆಲ್ಲ ಕಳ್ಸ್ಬಿಡ್ಲಾ ಕಳ್ಸ್ಬಿಡಿ ಇದಕ್ಕೆ ಇದು ಬ್ರಾಂಚ್ಗೆ ಬುಕ್ ಕೊಡಿ ಸದಾನಂದ ಅವ್ರ ಫೈಲ್ ಕೊಡ್ತಾರೆ ಇದೊಂದು ಜುಡಿಷಿಯಲ್ ಅದು ಕ್ಲಾಸಿಫಿಕೇಶನ್ ರಿಲೇಷನ್ ಅಲ್ಲೇ